Welcome to the second virtual hearing for the review of the Heritage Act 1977. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of this land. I would also like to pay respect to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. Today's hearing is being conducted virtually. This enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with the technology, I would ask for everyone's patience through any technical difficulties we can encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they are asked to rejoin the hearing by using the same link as provided by the committee secretariat. Today we will be hearing from a range of stakeholders, including the Heritage Council of New South Wales, the National Trust of Australia, professional associations and industry advocacy groups. Before we commence, I would like to make some brief comments about the procedures for today's hearing. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry, terms of reference, and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness, according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. Today's proceedings are being streamed live and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to? And could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they are not speaking? Please remember to turn your microphones back on when you are getting ready to speak. If you start speaking whilst muted, please start your question or answer again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so we can all be heard clearly. Also, to assist Hansard, may I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. I now welcome our first witnesses. Could each witness please state their name and position title and swear either an oath or affirmation, starting with you, Mr. Holworth.
Thank you, Chairman. My name's Frank Richard Howarth, and I wish to use an affirmation, and I'm just aware that I don't think I've been sent the copy of the affirmation anywhere. I was just looking in the link to the meeting, unless the committee could direct me to where I will find that.
If it hasn't been sent across or it's gone amiss, I can simply state it, and if you don't mind repeating after me, if you're comfortable with that.
Very happy, Mr. Chairman.
I solemnly, sincerely, and truly declare and affirm
I solemnly, sincerely, and truly declare and affirm
that the evidence now about to be given by me
that the evidence now about to be given by me
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Haworth. Mr. Condameri, could you please state your full name and position title and swear either an oath or affirmation?
Thank you, Chair. My name is Dylan Combameri. I'm Principal Architect for the Government Architect New South Wales within the Department of Planning, Industry and Environment. I'm also Chair of the Heritage Council Approvals Committee. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Condameri. Would either of you like to commence by making a short statement?
Thank you, Mr. Chair. It's Frank Howarth here, and I would like to do so. First, may I acknowledge that I'm on the land of the Wadi Wadi people of the Darawal Nation on the south coast and pay my respects to their elders, past, present, and emerging. Chair, yesterday we submitted to the Secretariat a brief supplementary submission from the Heritage Council, and rather than read that out, I would ask if the committee would accept that as a supplementary submission, and I'll just make some brief less than 2-minute remarks about it, if that's acceptable to the committee. Okay, thank you. Thank you, Chair, and thank you, committee. The first point that the Heritage Council wants to make is that any legislation around heritage in New South Wales should be about 3 things. It should be about celebration, conservation, and protection of heritage. And it's most important that I think that we remember that, and that heritage can be tangible and intangible, large and small. The second point is that a number of submissions we note to this hearing of the committee have suggested that the Heritage Act is adequate and needs no change. The council's view is it's a little bit like a 1970s car. It will get you round, but it's neither as environmentally sustainable nor as safe as something that's currently available, and that there are a number of deficiencies with the current Act. The first and most significant of which is that the Act is effectively silent on Aboriginal cultural heritage, and assuming it's managed by provisions of the National Parks and Wildlife Act in particular. Most importantly, the council feels that there are 2 principles that certainly the council accepts and believes should be part of any Aboriginal cultural heritage framework, and that is that Aboriginal cultural heritage should be determined by Aboriginal people. They are the primary and should be the determinants of Aboriginal cultural heritage. The second principle is that we people of New South Wales are all part of one framework of heritage that it's shared, and in the light of that, the council believes it would be better if there was one legal heritage framework, one Heritage Act that also embodied that principle of Aboriginal self-determination. Second key point to make is that the current heritage system works on a fairly blunt instrument. Once something is determined to be of state heritage and a curtilage is drawn around it, the Act assumes that everything inside it is of equal significance unless there's a specific exemption to that. That creates problems, significant problems for heritage owners, and the council believes that it's certainly worth examining the potential of reversing that presumption so that instead the presumption is that only those things that are determined to be of significance inside the curtilage are protected and regulated, and that other areas are left free for owners to do with as they see reasonably fit and within planning laws. Composition of the Heritage Council, we believe a mix of experts and community members who share a passion for heritage is the best way to go. And in particular, we believe that there should be at least 2 Aboriginal members of the council, 1 man and 1 woman, to better reflect the nature of Aboriginal cultural heritage. Council also believes that the current prevention of employing its own staff is not working. Council feels that, like other independent regulatory bodies, similar to, say, IPART or even ICAC, the council should have its own staff to ensure that it's able to provide free and fair advice to the minister as and when needed. We support a more refined category system with 4 parts. Most important, the highest level of that, if I can put it that way, the most significant buildings, like in the English, Scottish, and Irish heritage systems, should be singled out. Particularly, we believe that those few places that would be in that category, such as the Opera House, should not have that significance turned off by other legislation, as is currently the system. We believe there should be then two other tiers, one that's designed mainly for single dwellings and a second that's designed for precincts and landscapes. We support a third celebratory type of listing that does not have the regulatory heaviness and overlay of the other categories, and the government's recently announced blue plaque system would be a good example of that. Almost at the end, we recognise that listing is onerous and financially disadvantageous to a number of owners, and we believe that there should be an examination of a range of incentives that should offset that. Finally, that we believe that there should be a more effective compliance and enforcement framework that go alongside the carrots, if I can put it that way, and that there are models of this that exist in the environment area, such as the ability to issue penalty infringement notices. In summary, the Council believes that we do need to update the Heritage Act to better reflect the 21st century, particularly around Aboriginal cultural heritage, and to better enable the people of New South Wales to celebrate, conserve and protect their heritage in all its forms. Thank you, Chair.
Thank you, Mr. Hayroth. And for members, I understand that the supplementary submission will be emailed, and once again, if you don't have it before you. Mr. Combermere, would you like to also make a short statement, please?
Thank you, Chair. Only that I'd like to pay respects also to Aboriginal elders past, present and emerging, and acknowledge that I'm sitting on Wongal land today. Thank you, Chair.
Thank you very much. I'll now invite our members to commence with questions, and I'll go first to the Honourable Walt Secord.
Thank you, Mr. Chair. For the benefit of Hansard, it's Walt Secord speaking, and my first question will go to Mr. Frank Horwath. Thank you for your submission and your supplementary submission. They were very forthright and direct. Thank you. In your submission on page 6, you refer to your body as having, quote, conflicts of interests and being the subject of, quote, political priorities. How does that play out in your interaction with the minister and the government?
Thank you, Mr. Secord. I can better characterise that as the Council believes that the lack of an independent secretariat places the risk of a perceived conflict of interest. And I have to state at this point that in my term as the chair, I don't think we've come across a situation of actual conflict of interest. The way it plays out is that when in any situation, whether it's the Heritage Council or any other sort of regulatory authority or board, if the same body is advising the council as is advising, say, a minister on a particular political priority that relates to that, there could be a perceived conflict of interest. And I can use the analogy that if IPART, for instance, which regulates, amongst others, transport fares, was also being serviced by Transport for New South Wales staff, which has a vested interest in particular outcomes or might, then a perception of conflict of interest could arise. That's our concern, that an independent organisation, or an independent regulatory authority such as the Council, should have independent staff.
Okay, may I ask a follow-up then? So how does the Council interact with the Heritage Minister? Do you provide advice, unsolicited advice, or does he seek advice and opinion from your body?
Thank you, Mr. Secord. In effect, both. If the Council feels that there's advice we should give, we will give it, either directly to the Minister or through his staff. Again, an example would be the discussions around a potential new Heritage Act. The Council was formally asked by the Minister to provide advice on the Green Paper, which we did. But there are many occasions when we will advise the minister of an issue that we believe is emerging that he should be aware of, and that's our primary role.
Can I take you to a follow-up to that? Have you provided any evidence to the minister on Willow Grove at Parramatta?
No, Mr. Secord, we haven't. Willow Grove has not formally come before the Heritage Council for any particular consideration.
Have you provided any unsolicited advice to the government on Willow Grove?
No, we haven't. As I said, it's not a matter for discussion by or consideration by the Heritage Council.
I thought that, in fact, it would be something that your organization, your body would take an interest in.
There's a number of ways that a place can come before the Heritage Council, and the most common way would be a nomination for state heritage listing. To the best of my knowledge, Willow Grove has never been nominated for state heritage listing. So it hasn't come that way. To the best of my knowledge, the minister's certainly not formally asked for any advice. There are many locally listed buildings that come and go through local listing that the council doesn't see. In fact, the vast bulk of heritage listings in New South Wales are local listings. And I believe Willow Grove was locally listed. That would not normally come to the council.
But a follow-up that, wouldn't you think that the public interest and national coverage and national interest and potential green bans placed on the site would put it in your orbit, so to speak?
Mr. Secord, there's nothing in the Heritage Act that would suggest we should take, the current Heritage Act, a particular interest in Willow Grove. And as I said, the minister has not sought the council's advice on Willow Grove, to the best of my knowledge.
What is your view on Willow Grove?
I don't have a view on Willow Grove, as it's not a matter that's come to the council. The council has no particular view.
Point of order, Mr.
I
Chair.
think that is a point of order, Mr. Mallard.
And it's difficult to do the points of order on this virtual process, but clearly Mr. Secord is well outside the terms of reference of the inquiry, focusing on one particular building. We're reviewing the Act. The witness is an expert on the overall Heritage Act, and I think we're giving him some scope to explore that, but he's going taking the inquiry into an area which we don't need to go into.
I remind the honourable member that the last point of the terms of reference refers to other matters, and this is clearly an other matter, and this is clearly within the purview of this committee.
This is not an estimate inquiry. Walt, just have for estimates and get your media grab that way.
And Mr. Shoebridge has raised a point of order.
Well, clearly it's open to explore any problems with the current Heritage Act through a case study. I think that's clearly within order. We've got to review how the current Heritage Act is working to see how to reform it. I would have thought unquestionably Mr. Secord is in order.
Thank you.
And I fully agree with Mr. Shoebridge. I mean, this is a case example which may highlight deficiencies in the current Act.
Mr. Chair, may I in fact point out the first paragraph on page 2 of the council submission, and they talk about the Heritage Act being born, quote, in the era of bulldozers at midnight. That's what we have occurring right now at Willow Grove. So in fact, I think this is very, very, very important, and I would expect that the Heritage Council appointed, and which is striving to be an independent body and being at an arm's length from the government in its submission, asked for that, would have a view on Willow Grove.
Thank you. Thank you, Mr. Secord, Mr. Shoebridge, and Mr. Mallard. Could I just invite committee members to be mindful of the terms of reference? We do have limited time. It is useful to have witnesses appearing before the committee. Mr. Hayworth is also extended us the courtesy of providing a supplementary submission, so there is scope to focus on those matters separate to one particular issue. But Mr. Secord, did you have further questions to continue?
Okay, well, if the witness is declining to answer questions about Willow Grove, I'll then take it to the. He talks about the different levels of heritage. And in his opening statement and in his submission, he referred to, I think, 4 levels or 4 tiers. So on those areas of heritage, and that, does he see that Willow Grove is a minor heritage level tier matter?
Thank you, Mr. Secord. I would not use minor as your words. My understanding is Willow Grove was, at least, locally listed. The council does not believe there is any need to change the sense of local heritage listing. That is heritage determined by local communities. So we don't have a suggested change to that category.
Okay, now you talk about, well, do you have a view then on dismantling and removing a heritage, a locally listed heritage item and relocating it to another facility, another location?
Mr. Secord, you asked me almost the identical question in the Powerhouse Museum hearings, I think, and I'll answer it now the way I answered it then. I'm not going to talk about specifics, but I will say that in general terms, the dismantling and relocating of a heritage building reduces its significance, both of the building and potentially of the place it's located to. That's a general principle of heritage.
Back to don't you think that if you're seeking an independent statutory body as the Heritage Council, having an arm's length of government, that you should begin to offer robust opinions on significant matters of heritage like Willow Grove?
It's a value judgment, I guess, Mr. Secord, of what significant matters of heritage constitute. The council believes, for instance, a significant matter of heritage is the fairly woeful state of recognition of Aboriginal cultural heritage. Therefore, we devote quite a substantial amount of time to considering that and have provided advice to the minister in various ways around that. As I said, the council does not believe that the local heritage listing system requires substantial change.
Okay, I thank you for your submission on Aboriginal heritage, and I do take your points, and I do agree with your conclusions. Can I take you to another aspect? You refer to, on I think page 4, you refer to migrant heritage being the least protected. What were you referring to when you made that submission?
If I can answer that slightly the other way around, what is on the state heritage register is dominated by what I might very generally call an Anglo-Saxon sort of dominant view of heritage. So, a large number of railway buildings and sandstone churches, and communities that have arrived more recently and their heritage is underrepresented. We've started to significantly address that. We advised the minister a while ago and he accepted our advice to list 2 Sikh temples in Woolgoolga on the north coast of New South Wales. And in my point about a 1970s vehicle, we listed 2 buildings which were really recognizing the cultural significance of Sikhism to that community, which is a less tangible sense, and the current Act doesn't really cope with that. So our best way to achieve that is to list the 2 Sikh temples. So we've been seeking, sorry, my apologies for the pun. We've been looking to find places of significance to migrant communities and move more listings that way if we possibly can.
Yeah, I understand recently the minister actually made reference to a desire to include more migrants in colonial areas, such as the listing of the Goulburn Jewish Cemetery was one that I actually saw that he referred to. Now,
Mr. Secord, could just mindful of time, we've sort of gravitated towards our crossbench friends. So,
thank you, Mr. Chair.
Reverend Mr. Shoebridge or Reverend Knoll, do you have a question?
Yes.
I recognise Mr. Shoebridge in the first instance.
Oh no, let Fred go first. You can go first, Fred.
An issue's been raised with me. The Aboriginal communities have asked for a building to be earmarked as an Aboriginal War Memorial Museum. They need a place where they can exhibit a number of movable heritage items that relate to the Aboriginal wars and massacres. The Sydney Living Museum has operated the Endangered Houses Fund since 2005. The fund purchases properties, carries out appropriate conservation work, and places suitable protections, such as heritage agreements on the property. Could one of these restored heritage properties become an Aboriginal War Memorial Museum?
Thank you, Mr. Nile. I suspect that is slightly outside the purview of the Heritage Council per se, and probably is better addressed to Create New South Wales and or the Minister directly. The Council certainly believes that the storage and recognition of Aboriginal cultural heritage materials could and should be done better. I think that it's one of the things that's been a slight anomaly since the 1970s. I believe in that era it was not recognised was not even generally accepted that every square centimetre of New South Wales is Aboriginal land, and therefore there will be traces of Aboriginal heritage everywhere. Where that heritage should be stored, movable heritage, and recognised is a significant issue, and I think that the council would accept that. But the matter of whether something should be repurposed as a museum probably fits better with the minister and his role in the arts and Create New South Wales area.
Reverend Knowles, the chair, did you have any
Yes,
follow-up questions?
another quick question. Does the New South Wales Heritage Council have a specific department that oversights Aboriginal heritage listings?
The short answer is no. The council does not, as I mentioned earlier, the council does not have its own staff. Heritage New South Wales, however, I understand, has taken over all of the staff that were formerly within National Parks and Wildlife who deal with Aboriginal cultural heritage matters. So my understanding is now there is one part of Department of Premier and Cabinet, Heritage New South Wales, that handles all Aboriginal cultural heritage matters, whether they derive from powers in the National Parks and Wildlife Act or indeed the Heritage Act.
Thank you. That's all my questions.
Thank you, Reverend Knoll. Mr. Shoebridge, please.
Thanks, Chair. Thanks, Mr. Howarth, and thanks for the submission from both of you and from the committee. Could I start with asking you, do you think there's anything missing from the three, I think they're described as three key policy themes that the government has to guide its heritage review? They are making heritage easy, putting heritage to work, and making heritage relevant. And I'll just be very clear where I'm coming from on this. We've had multiple submissions that say, why isn't the first guiding theme protecting heritage? But do you have any views?
There could be a very long answer to that, Mr. Shoebridge. We accept there are, I think we, the Heritage Council, would accept there are issues in all three areas. If I can answer that slightly differently, I think the current system and its supporting staff puts a great deal of effort around the regulatory / protecting end. And that protection, as we set out in our submission and I mentioned earlier, is in some senses a fairly blunt instrument, but it's also a blunt instrument without adequate penalties, in our view, for people who don't do the right thing with heritage. The other principles around heritage, I think, is that we believe that any Heritage Act, like in some other places, might best start with a recital of principles around heritage, and that is the importance of heritage to communities in so many ways, either directly economically through things like heritage tourism, or the sense of community well-being, which is palpable if you go to a place like Tenterfield and walk around. You can and talk to people. You see that there.
Howard, could you focus on those three guiding themes that the government has put forward: making heritage easy, putting heritage to work, making heritage relevant? It does seem to me that most of what you're putting now, which I would firmly agree with, at best fit obliquely into those three themes.
Okay, if I can take it specifically, making heritage easy. We believe there are ways to simplify the listing process substantially. We believe that a process more akin to that starts with an expression of interest so that applicants don't have to submit a huge amount of work only to find that something is not significant, or indeed, as happens in a surprisingly large number of cases, is already listed, so that the application process can be simplified. The approvals process, whereby something that is listed is worked on, through Dylan's leadership, Mr. Combermary's leadership, we've embarked on a system that's much more about working with proponents to simplify the approvals process rather than a very direct regulatory process. Making heritage work, I think it's recognizing that heritage can be, if done well, a very good economic driver, and relevant. Heritage has got to be meaningful to everyone. And I think systems that are celebratory, like the Blue Plaque system, go some way to making heritage more directly relevant to community members.
Mr. Howarth, it's David Tribucci. You're pushing against an open door that each of these three things probably have importance. But what I'm asking you is it missing what should be the central plank and the central pillar for heritage reforms, which is protecting heritage? It seems extraordinary to me that not one of the guiding themes is about protecting heritage. Does the Heritage Council have a view about this?
The Heritage Council, I guess, set out its view pretty well in our initial and then supplementary submission. We based our view on those three points: celebrate, conserve, and protect. And I emphasize the word protect, which is the regulatory part of the current Heritage Act, and that regulatory system has got to be there. And in fact, we argue for beefing up the compliance side of the regulatory system. So I'm not entirely sure what you're getting at in that respect. The council is not advocating certainly not advocating any lesser approach to protection.
South, it would never cross my mind that the Heritage Council would be asking for less protections. But what I'm suggesting to you is conserve and protect, being two of the three pillars you put forward, are not found expressly in the three pillars the government puts forward. And I'm asking you whether or not you think the three pillars that the government puts forward are adequate guidance for a review of the Heritage Act, given they don't include two of your three key elements, which is conserve and protect.
Mr. Chair, Mr. Shoebridge, it's not the council's wish nor my role to provide a view on what the government does or doesn't put forward. We provide advice to the government, and we have, and it includes significant protection. As you will have noted, our submission is not framed as a direct response to the Green Paper's questions. It's framed more as a more holistic view, we hope, of how heritage should be treated, which again contains a significant amount of protection. I'm sure the Minister, Don Harwin, and government will take that on board, or at least consider that.
Well, one of the issues you raise in your submission is the conflict of interest you have, where you rely upon the same staff for providing you with advice and guidance in terms of protecting heritage and performing your statutory function, as the government relies upon sometimes for some quite radical changes to heritage items. I put that conflict of interest issue to their minister, and he denied there was a problem there. He rejected the idea that there was a conflict of interest which compromised the work of the Heritage Council. Can you give us any further information about how that works in practice?
Well, the short answer, Mr. Shoebridge, is no. As I said in earlier comments to Mr. Secord, I think it's about a perception of conflict of interest, and it's not necessarily about even a current government. This current act has been here since 1977, and I guess the committee would know even better than us that in designing legislation, it's designed not necessarily for the here and now, but for the future and for a range of circumstances. The council's view is and remains that there could be a significant perception of conflict of interest when a single agency is providing advice both to an independent regulatory body like the council and to a government which has policies that it wishes to put in place. That puts the agency, not the council. The council doesn't have a conflict of interest. Our concern is it potentially puts the agency in a position of conflict of interest.
Well, Ms. Howard, I'll just read from your submission and ask if you want to in any way backtrack from it at all. You say there are situations where the minister responsible for heritage, or indeed the government in general, are on the one hand seeking independent advice from the Heritage Council on whether a place is of state heritage significance, while at the same time other agencies may be pursuing projects which impact on places of potential state heritage significance. In those situations, the staff of Heritage New South Wales is advising both the Heritage Council in its deliberations and at the same time advising the minister and government on how to achieve their policy intentions. This can create a potential conflict of interest for those staff. Well, if they're in a conflict of interest and you're relying upon their advice, it's inevitable that you have a conflict of interest, isn't it? You don't have some magic solution to that.
Mr. Shoebridge, I think maybe yours and my understanding of conflict of interest is slightly different here. It's the board feels that the conflict of interest, the council feels the conflict of interest could be perceived to reside with Heritage New South Wales because it's giving supposedly independent advice. My example earlier is a situation where, like, the Independent Pricing and Regulatory Tribunal regulating transport fares, if it was being advised by the department, the relevant transport agency, which has a vested interest potentially in a certain level of fares, would give rise to a perception of conflict of interest. So no, we don't backtrack from our remarks at all. It's a question of, if a body is independent, how does it obtain independent advice? Now, to answer the final part of your question, there have been cases where the council has said, we would like independent advice, and then with the support of Heritage New South Wales, and indeed the funding from it, had independent consultancy advice. So that's one way we manage the current situation. But we believe in setting up any new act, there should be some substantial thought around how an independent advisory body obtains independent advice.
An advisory body is only as good as the advice it gets. And if the advice you're getting has an inevitable conflict of interest, well, that inevitably impacts and degrades the independence of any of in this case of the Heritage Council, doesn't it? You have to accept that being dependent upon the advice of government employees for the bulk of your work erodes the independence of the Heritage Council, and it's something that should be reformed in a Reformed Heritage Act.
Yes, that's what we set out in our submission.
Thank you, Mr. Howarth. It's the chair here. I'll now invite governor members and acknowledge Mr. Franklin.
Thank you very much, Mr. Chair, and thanks very much for being here, Mr. Howarth. Can I just ask a specific question to start with? Your submission refers to developing a heritage investment fund, and I wonder if you could talk to us a little about how that might work and contribute to conservation outcomes, achieving conservation outcomes in New South Wales.
Thank you, Mr. Franklin. I guess the analogy I would draw is I think it's called the Biodiversity Conservation Fund in another part of government under the Biodiversity Conservation Act, which in my understanding was set up to allow deductible gifts to it to create a fund for biodiversity conservation purposes. We believe there's an analogous situation that could apply to heritage. We note in our submission that heritage owners, in a number of ways, are financially disadvantaged, and that provides perhaps an unintentional disincentive to working on heritage properties. A heritage conservation fund might be used in a couple of ways, either by direct application by particularly private heritage property owners to enable them to support work that is required to maintain their property. It might also be used to purchase heritage properties. As Mr. Nile earlier mentioned, the fund that's managed by Sydney Living Museums is an example, the Endangered Houses Fund, I think. Such a fund could purchase heritage properties, enable their updating, making suitable for adaptive reuse, and then either through long-term leases or sale, getting them back out into operation again. So we believe such a fund with a fair degree of flexibility and deductible gift recipient status, if the Commonwealth agreed to that, would be a very good vehicle for heritage protection, or heritage conservation, I should say.
Thanks, Mr. Howarth. And just a second question, a broader question. Can you talk to us about what your view is what intangible heritage is and how we could potentially incorporate intangible heritage into the Heritage Act?
Thank you, Mr. Franklin. Intangible heritage, I mentioned the example before of the Sikh temples. Intangible heritage is by its very name not something that you can touch and feel and pick up. It's some examples, I guess. The one that's most bleedingly obvious to people would be the sort of heritage, the intangible natures of nature of Anzac Day and the celebrations around that. Another less obvious one that's been cited to us would be the tradition of life saving on coastal New South Wales and how that has shaped life on coastal Australia. Then, much more specifically, we use the Heritage Act by slightly bending it to recognise a very significant area of Aboriginal intangible cultural heritage through recognising the women's country near Calgary on the central coast of New South Wales. That heritage is tangible, certainly to those women for whom it's significant, but it is not something you could touch and feel. Similarly, in the lead up to the World Pride in 2023, we're thinking about how might we recognise LGBTIQ life changes, intangible life, changes, intangible heritage in New South Wales. So that's the sort of things we're thinking about. Typically in other countries, that is recognized usually more through a celebratory approach. English Heritage, for instance, has published a number of podcasts, apps, and documents that are around aspects of intangible heritage and link them to, say, buildings and places that might recognise that. For instance, Taylor Square in Sydney is currently listed, although unfortunately primarily for engineering and sanitary reasons rather than LGBTIQ reasons. But if we link that to the tradition of gay and lesbian rights, then we start recognising more intangible heritage.
Howth, I think my colleagues might have a couple of questions as well.
I think Shane's trying to unmute.
No,
There he goes.
Mr. Mallard, could you just identify yourself and
It is
proceed?
Shane Mallard. I am myself. I'm using an iPad. That's why I have a bit more difficulty trying to log on. Thank you for your submission, Mr. Howth, as always. The Minister in his presentation to us and a number of the submissions talk about the problems with standard exemptions and the complicated approval process. I'm very keen about the preservation of curtilages and landscapes around heritage buildings as well, and the Minister talked about those issues. So what's the Council's view on the complications of the exemptions process?
If I might begin to answer that, then defer to my colleague Dylan Combermary as well, because the Approvals Committee,
I was hoping he'd get a question.
would handle that. From the Council's point of view, we've been going through a process of, well, let me put it the other way. When I took over as chair, we had this very strange process which you as a heritage property owner got a whole set of standard exemptions. I mean, you could repaint the house the same colour, but you had to apply for permission to exercise a standard exemption, which became a bit of a nonsense. So with very strong support of the Minister, we've changed that. There's now a much more significant range of standard exemptions, which don't need any sort of extra permission. On top of that, the Council working with the Approvals Committee, I think, has made a significant philosophical change about how what's known in the trade as Section 60 approvals, which is significant approvals, work. So I might, if the committee is happy, can I defer to my colleague, Mr. Combermary, to talk about that?
Sure.
Thanks, Frank. Dylan Combermary speaking. So the recent approach that we've undertaken under Frank's stewardship and support by the Heritage Council, is to appreciate that owners of heritage buildings are looking after important assets for the wider community who have shared connections with those buildings and places. We also accept that buildings need to be modified or owners of properties are seeking to modify their building to suit modern living practices, but also to comply with current regulatory and safety standards. So there's a bit in that, and what we try to do is work with applicants, proponents, in a series of workshops to do two things. Obviously, to protect the heritage values that we think are important for these places, but also to try and find a suitable outcome for the proponents and the objectives that they're wanting to achieve. If I could maybe give an example of that, an owner has a terrace house, often they're small rooms, and they're wanting to join two rooms. So there's a wall separating the two rooms, and the approvals committee have on several occasions accepted a central opening, which leaves part of the wall intact while still defining the two rooms as distinct spaces. So that sort of goodwill, I think, is resonating. We are seeing, often similar consultants supporting applicants that are, I suppose, appreciating that we're working with them as opposed to against them. And I think that's bearing some fruit, that there seems to be, from certainly my experience, a willingness to really, take on the heritage values that we're seeking to support. I think if that answers your question.
Okay. Well, to a point, is there a role for a thorough conservation management plan that's been ticked off by the authorities that gives a scope for those sort of activities to occur without having to go backwards and forwards for approval?
Short answer is yes. So we do refer to those CMPs to help us defend the cultural values of a place or a building. But as I said, in recent experience, there is much more willingness to work with us to support and protect those values. And we in turn, because we accept the building was built in a different time and there are different needs and living requirements of a modern time. And so, we're seeking to support the objectives of that as well.
But wouldn't a conservation management plan, a good one, a thorough one that you've signed off on for a building, that goes scope for those maintenance and repairs, and we're having run backwards and forwards for approvals, would that be a path to go down?
Sure. We work with Heritage New South Wales, and often we defer to them and say, look, we think this is something that you have great skill and knowledge about, understanding and working with the applicants, and so we often defer to them as well to follow that through.
Okay.
Right. Mr. Chair, could I add a supplementary? Sorry, it's Frank Howarth here. Mr. Mallard, if I might just add some overarching Heritage Council comments to that. The council has just gone through a very long process, 2.5 years, of completely reviewing the conservation management plan system with very extensive consultation with not only heritage property owners, but also the heritage advisory industry, if I can put it that way. Because I think the council shares the view that you articulated, that a good conservation management plan should be the primary document to guide the future use, whatever, of a heritage property. I think that has been put into practice most obviously now with work around Millers Point, where a large number of properties were sold very quickly by the government of the day with conservation management plans, but many of those plans were prepared in a great deal of haste, and there were perhaps inevitable consistencies across those. So the council, particularly through Dylan's committee, the approvals committee, has been working with the community in Millers Point, again, both the heritage industry and the property owners, to move towards a much more consistent approach. There is one single conservation management plan for Millers Point, but my view is probably significantly out of date. And again, we'll work with the community to update that framework. So we avoid situations where one property owner with one plan can put For instance, an air conditioner on the roof of their property, the place next door has a different plan that says you can't. That's the sort of inconsistency that through Approvals Committee and the Council we're working to get rid of.
It's a chair now speaking. Can I take this opportunity to thank you both, Mr. Howarth and Mr. Condameri, for attending the hearing today. Thank you for your participation and for your patience. And thank you.
Thank you, Chair.
Thank you.
Thank you,
You're
Chair.
welcome.
Thank you, committee.
And I'll remind the committee members that we're about to go on a brief break until 11 a.m. this morning to facilitate the changeover of witnesses. I'll remind the committee members that during this period, could you please go on mute, and you can also turn off your video until we resume just before 11 a.m. Thank you.
Go on mute.
Could I just, it's the chair speaking, could I just ask Mr. Romney and Mr. Burden if you could both help us out with a quick sound check, please?
Yes, it's Peter Romney here. Can you hear me?
Loud and clear, thank you.
Thank you.
Yes, and this is David Burden.
Thank you, Mr. Burden. Well, good morning and welcome to the review of the Heritage Act 1977. The committee is now resuming proceedings. I'll take this opportunity to welcome Mr. Peter Romney and Mr. David Burden. And each of you please state your name and position title and swear either an oath or affirmation.
Thank you, Chair. Peter Allen Ramey, my position today is representing Australia Icamos. I'm also a heritage consultant and director of a company that specialises in cultural heritage work. Well, I'll take the affirmation now. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Romney. And similarly, Mr. Burden, could you follow the same?
Yes, my name is David Russell Burden. I'm the Conservation Director at the National Trust of New South Wales. I'm a registered architect in New South Wales. I'm also I'll state that I'm a member of the Approvals Committee, of which Mr. Complimentary just appeared. I'll take the affirmation as well. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you so much. Would you like to both begin by making a short statement addressed to the committee?
Thank you, Chair. I'll go first if that's convenient. My name is Peter Romney. I'm a long-standing member of Australia Icamos. I've been appointed by the President of Australia Icamos to appear before your committee. And in doing so, I hope I'll be able to assist you in understanding the matters we have raised in our submission in response to the discussion paper released in April of this year. ICOMOS is the International Council on Monuments and Sites, a non-government professional organisation that promotes expertise in the conservation of cultural heritage. ICOMOS is an official advisory body to the World Heritage Committee under the World Heritage Convention. And Australia Icamos is the national branch of ICOMOS, one of over 100 national committees throughout the world. Just very briefly, to understand a little bit of the background about where we're coming from, our priorities include, I won't read them all, but the relevant ones are: one, to advance and promote national standards and best practice in heritage, to engage with contemporary issues in cultural heritage, and to be an influential voice to government. We have over 750 members in a range of professions, and that point is, I think, an important one. I do not have an exact figure, but I'm confident that a significant majority of our members actually work in the development and mining sectors, providing advice and preparing reports about heritage issues for government, institutional and private clients. These inputs are often sought at a very early stage when reliable due diligence is essential in making good decisions about how and even if a development should proceed. So our organisation could hardly be described as anti-development when so many of our members rely on these projects and clients for our professional livelihood, including myself. So we welcome the review, notwithstanding that our submission raises what we believe are important concerns about some aspects of the direction outlined in the discussion paper. And these concerns are based on what we see as current shortcomings in the way our heritage is currently protected and managed. And they're certainly not an ideological belief. They don't reflect an ideological belief that best practice heritage management and development are mutually exclusive. So just briefly, our concerns can be summarised as follows. The Heritage Act can be improved, but we don't believe it needs major reform. In our submission, we suggested some areas where there might be some refinements, however. The Act and its implementation needs to be much better supported and resourced. And this resourcing should extend to better support for local government as well, not just New South Wales Heritage and the Heritage Council. Local government's responsible for the legislative protection and management of over 35,000 listed heritage places. And we believe that a well-resourced and customer-focused support at the state and local government level would be a very effective incentive for the owners of heritage places, making owning a heritage place easier. We don't think that's currently the case. A high priority for legislative reform should be the long-promised reforms related to Aboriginal heritage, and that Aboriginal stakeholders must be intimately involved in this process. We do not support the proposed categorisation of heritage places. The one-size-fits-all description is an oversimplification, is what actually a rigorous basis of heritage management, which is entirely consistent with the Australia ICMOS guidelines for managing change to heritage places, which is the Borough Charter. This methodology is generally utilised across all jurisdictions in Australia and is widely used internationally. It is based on a need to understand what is significant about a place before making decisions about appropriate change. That process is the same whether it's at the Terrace House in Millers Point or the Sydney Opera House. The principle is the same. So the one-size-fits-all is not an appropriate way of describing that process. I've nearly finished. A key reform of the Act should be to ensure a substantial majority of the Heritage Council members have considerable heritage expertise. Furthermore, we believe that the listing or possibly even delisting places on the State Heritage Register should be the role of the Heritage Council rather than the Minister. Our final point, we're concerned that the discussion paper does not address what are major problems with current processes related to state significant development applications. If the approval provisions of the Heritage Act are switched off under SSD and the inevitable heritage issues are addressed at a late stage of the project, especially for unsolicited developments, which happens, this is a major concern for our state significant heritage places and should be considered as part of the review. Thank you for allowing me to start the proceedings with this presentation. I'll be happy to take questions from the committee with the proviso that given the breadth of the matters raised in our submission, there may be queries that I would need to take on notice. Thank you.
Thank you, Mr. Roney. And similarly, Mr. Burden, would you like to make a short opening statement?
Yes, I would. Thank you, Chairman. So my name is David Burden. As I've stated, I'm the Conservation Director of the National Trust of New South Wales. And in the spirit of this inquiry about our heritage, I'll just begin by acknowledging the original inhabitants and the custodians of New South Wales. And I note that the Procedural people of the Eora Nation are the original inhabitants and custodians of all the lands and waters in the Georges River area where I'm currently speaking from. As I'm sure you're aware, the National Trust of Australia is the oldest and largest independent conservation organisation in Australia, and we have over 22,000 members across New South Wales. Our register formed the basis of the current State Heritage Register, with the majority of local environmental plan listings as well in New South Wales coming from the original National Trust list. And since 1945, the New South Wales National Trust has been the leading advocate for the protection of the built and natural heritage in our state, and 29 of our 35 properties are listed on the State Heritage Register. The Heritage Act is of fundamental importance to the identification, protection, promotion and conservation of heritage in New South Wales. Any proposed amendments must result in better heritage outcomes rather than a weakening of heritage protection. And our submission has been made, framed on that basis. When we found out about this review, after we read the discussion paper, the National Trust immediately recognised that the community needed to be made aware of any proposed changes to this important piece of legislation. Our submission is the result of extensive community and professional feedback and includes the outcomes from a very well attended Heritage Forum that was run by the National Trust on the 9th of June 2021, which specifically focused on the Heritage Act review. This was a sold-out free event attended by over 300 people. It was facilitated entirely by the National Trust. The event was recorded and placed on our website so that people all over New South Wales could be involved. One of our key aims was to ensure there were a lot of submissions to this inquiry, and we were delighted to see the 297 submissions that were made. I think that this shows the concern, the passion and the engagement with heritage that exists across New South Wales. For the National Trust part, I would of course refer you to our detailed submission, but to suffice it to say that there are just 5 key points that I think are just worth repeating in my opening statement. Firstly, the Heritage Act, by and large, is a good piece of legislation, but any comments related to its effectiveness must of necessity be tied to the resources, both in terms of funding and expertise of the Heritage Council and by association the Heritage Office. The Heritage Act must be resourced properly. The government must urgently prioritise Aboriginal cultural heritage reform, and Aboriginal people need to be involved in this process. Thirdly, there's been a recent trend towards delegating responsibility for our heritage, and none more so than with the move towards some more self-assessment. So heritage can be easy, but it shouldn't be too easy. Heritage protection must not be given away. Fourthly, the independence of the Heritage Council must be maintained, and its membership must be capable of giving the necessary expert heritage advice that the community would expect from such an august body. The Heritage Council must be respected. The Minister has made it clear that no change is intended, but probably the single most important thing that we've long maintained and which our community forum confirmed is that the Heritage Act needs to be applied in order to be effective. To essentially turn it off in relation to state significant infrastructure and state significant development makes a mockery of the whole planning system. The Heritage Act must be enforced. Otherwise, we have to question why we're here today. Thank you, Mr. Chair.
Thank you very much, Mr. Burden, and I'll now invite members of the opposition if they have any questions.
Yes.
And I recognise the Deputy Chair, the Honourable Mark Buttigieg.
Thank you, Chair. Mr. Romney, in your introduction, you stated that you thought there was a degree of problems with the Minister making decisions regarding listings and delistings. Could you just enlighten us as to how that process works at the moment? Yeah, presumably the Minister is not across every single item that gets listed and delisted and seeks advice from some quarter. So maybe just to inform that view, could you just enlighten us as to what the process is at the moment?
Yes, thank you for the question. Under the Heritage Act, the Minister, I don't have the exact words in front of me, although I could get them. The Minister generally makes a decision on whether to list something or not on the advice of the Heritage Council. I think the Minister is able to list things through other means, but primarily whether the Minister adds something to the State Heritage Register or not would be on the advice of the Heritage Council. But that's advice, not, it can be strong advice, but nevertheless the Minister has to say.
So, okay, just in terms of a follow-up to that then, so in terms of the weakness in that current process, is the implication from your statement that the Minister may have other countervailing influences which override that advice inappropriately sometimes?
Well, I think it's in a real world situation, it's inevitable that the minister would have other issues or other considerations other than heritage significance that might determine his decision. I mean, I suppose that's understandable, and that may influence his decision. And it is in the political arena, I suspect you would say, whereas most other state heritage jurisdictions in Australia, the Heritage Council itself makes the decision about whether to list something rather than a member of the government.
So is that, Mr. Romney, Mr. Romney, is that, I notice a common theme in a lot of the submissions is this ability of state significant development to come in over the top of recommendations that the Heritage Council might make. What you're saying, presumably, is that model that's practiced in other jurisdictions, whereby the council gets to make the decision, would obviate that problem, would it?
No, I think we're, with respect, I think we're talking about two different issues here. That the listing process is quite separate, and so it should be, from the process of making decisions about whether a development of the heritage item is appropriate or not. That happens down the track, and best practice heritage management insists that those two processes are quite separate. In the first instance, whether a place warrants listing on a heritage register, state or local or national, should be determined primarily on the basis of its value to the community as a heritage place. Whereas the issue with state significant development affecting state listed heritage places, as an example, I would say, the Chief Secretary's building at the moment, which is subject to an unsolicited development proposal, that where SSD is invoked, the approval provisions of the Act are switched off, there is still a heritage approval process, but it's a separate approval process. And the Heritage Act, which is really there to protect places of state heritage significance and to consider carefully and go through a rigorous process of assessment whether the development is at odds with the heritage values or the place or not, is switched off. The other problem with SSD is that because so many of these developments are unsolicited, they do reach a stage in the process that's usually quite advanced before the heritage issues are looked at properly. So, for instance, if as the result of a concept or an unsolicited development proposal, the floor space ratio or height controls or both are changed in the immediate vicinity or even on the same site as a heritage item, that builds a high degree of momentum, developmental momentum. And so by the time that the rigorous heritage assessments are made, they're dealing with something that's very, very advanced in its in the process, and it's very difficult to turn around and say, well, if this is the case, it's not necessarily the case, but where it was the case that the height controls and the FSR controls are inappropriate, it's very difficult to wind that back at an advanced stage of the process. I hope that was that. As I said, the emphasis though there is that the listing and the heritage development process are quite separate.
Peter, I don't want to monopolise the questions. Did you have any?
Just two, if I may. This is to both witnesses, but particularly to Mr. Burden. If I can just go to pages 25 and 26 of your submission. I'm just wondering if you could please talk further about the role of local government, and particularly the issue about the adequacy of heritage funding. I noticed that Your second recommendation is that local government must be adequately resourced to care for the over 40,000 items on local heritage lists. Can you just talk to both of those pages, please?
Yes, David Burden speaking. Look, as you're aware, there are two tiers of, essentially two tiers. There's the State Heritage Register listed items, which are on the State Heritage Register, and there are the locally listed items, which are under LEPs. There's a lot more locally listed items, as you've just identified there. There's 40,000 of those. The situation at the moment is that they are, as the previous witness has confirmed with you, under the protection of the local councils. Essentially, the problem is that there's been a decrease in funding of local councils in terms of how they can best manage their heritage items. The National Trust has, in our forum, identified that the number of local heritage advisors is quite stretched amongst quite a large number of councils, and some of those councils indeed cover quite large areas. So for one heritage advisor to be travelling all over the place, often giving advice to several councils, means that their resources are quite stretched. So the concern is that without properly providing to local councils the funding to allow for heritage advice to be given, that a lot of these things will slip through the cracks, and that proper assessment won't be undertaken.
Thank you. The other one I just ask if you could please talk a bit more to would be, again, on page 26, and I suspect it's related to the same issue of resourcing. And I'm concerned about your comment about numerous key guidelines available to assist heritage owners are now out of date, and confusingly refer to legislative requirements that are no longer in force and approval processes that are no longer in place. And there seem to be already, what you've listed here, a number of those guidelines. Are there also other guidelines, and also are there regulations that we need to be looking at as well?
Yes, David Burden. Look, there are a number of guidelines that are provided by the Heritage Office of New South Wales on their website, and I must say that their website has recently undergone some updating. So that's occurred after this submission has been made, so I'll just make that note. But the point is that there are a number of guidelines, and they are quite old. Often the case is that sometimes, without those guidelines being updated, they might contain advice that actually doesn't apply any longer. There are particular examples there where you can see that there's been moves towards handing out self-assessment for certain items of repair and maintenance. There are updated standard exemptions. And so some of the things that are in the current standard exemptions that were signed off by the current Heritage Minister might not necessarily be applicable to the guidelines. And the National Trust itself does get quite a few telephone calls from people trying to work out which piece of legislation or guideline is in fact current. And so that's where the problem is there. It can be easily remedied, of course, by just updating the necessary guidelines to reflect any current changes.
Peter Primrose again. Can I just ask then, is it the case that these misleading guidelines could mislead people to actually be in breach of some particular regulation?
David Burden. Yes, I think that is the case. And it's interesting reading some of the submissions where that have been made. And I'd cite perhaps the Anglican Church Property Trust's one, where there's been an example given of where some work was commenced under what was thought to be an applicable guideline, and was then halted, delayed the costs, delayed the time, had to get approval, and then the work proceeded as it was going to anyway. But so that might be one small example of where something like that could occur, yes.
Okay, thank you, Mr. Chair.
Thank you, Mr. Primrose. I'll now invite our crossbench colleagues to raise questions, and I noticed before Reverend Nile had raised his hand. Reverend Nile, please. Reverend Nile, if you can hear me, you might still be inadvertently on mute. I just think as Reverend Nile works through that opportunity, I might invite Mr. Shoebridge if he has a question.
Thanks, Chair. Thanks to both of you for your submissions and your evidence today. So, and I suppose I wanted to go back to the fundamental principles that seem to be underpinning the government's reform agenda. They talk about their 3 key policy themes in their discussion paper about making heritage easy, putting heritage to work, making heritage relevant. Those 3 themes are discordant with the 3 themes put forward by the Heritage Council, which talked about conserving and protecting heritage. I wondered if the National Trust had a view about whether or not those 3 themes are an adequate reference point for something as critical as a reform of the Heritage Act.
David Burden. Look, I think that those, the making heritage easy, putting it to work, making it relevant, they're a bit, if I put it bluntly, sort of marketing speak. I do agree with the Heritage Council's 3 key objectives, if you like that you've referred to there, about celebrating, conserving and protecting. I think that those 3 principles are far better guidelines for the sort of review that we're talking about here. And certainly conservation and protection of heritage is the first steps towards celebrating it. We can't do one without the other, of course.
Mr. Romy, did you have any views about that?
Well, very similar to the National Trust view and the Heritage Council's view, and I do think that the protection and best practice management of heritage places has to be at the forefront of everything that we do. Just bear with me for a moment, sorry. Just my phone ringing. We did comment in our paper that even in the Heritage Act, notwithstanding the fact that we don't think it needs much uplift, much revision, that the Act is there to actually achieve those ends, needs to be more strongly put within the objectives of the Act, and it is unfortunate that they're not more strongly put in the discussion paper as well.
Yeah, well, thanks, Mr. Roach. More strongly put is an interesting construction, because as I read the discussion paper, apart from a reference to the existing objects in the forward, there's nowhere in this discussion paper where it's prioritising conservation and protection of heritage. Now, Mr. Burden, that seems to me to be require a fundamental rethink if those 2 critical elements are not found in the 3 key policy themes. Do you think this should have a sort of go back to first principles on that?
David Burden. Thank you, Mr. Shoebridge. I think that I would point the committee to the actual objects of the Heritage Act in section 3, right at the beginning of the Act, and that sort of comes to the core of it. It's to encourage the conservation of our state's heritage. It's to identify our state's heritage, and I think that they're 2 of the points to be made there. Is it sort of goes back to an earlier question that was raised. One is the identification of our state's heritage, so making the register, putting things on the list. And then the second part is that management of it. That's the conservation part. So we're identifying and conserving. One of the shortcomings, perhaps, of the way that things are at the moment is the first point of the Heritage Act. The objective is to promote an understanding of the state's heritage. I think that that's the part where we can start to talk about celebrating, getting wider community awareness, all of that sort of thing. I think that certainly could be improved, but it's certainly just one of the objectives, not that one has primacy over the other.
Thanks, Mr. Burton. But surely protection and conservation needs to come first. If you're not protecting it and conserving it, it's pretty bloody hard to celebrate it, isn't it?
David Burton, as per my previous comment, yes, of course, we need to conserve our heritage items in order to have them and in order to enjoy them. None more so than, for example, the current state with Central Station, you're all aware of, but there are significant concerns there that we are not going to be able to celebrate the heritage values of Central Station quite as much in the future because we're not protecting it as much as we should be at present.
Well, that actually, I was going to go on to Central Station and ask you both to very briefly articulate your concerns there, and particularly, Mr. Burton, if you might start with how the Heritage Council has largely been sidelined through the unsolicited proposals process and then state significant development. How together that really just makes the Heritage Council almost irrelevant in that process. Could you talk to that?
David Burton, look, I'll let the Heritage Council provide you with a proper response on that, but they have been involved, and I do note that they have made comment on it. So I'll just put that out there. What I would say, though, is that this is an unsolicited proposal for the Atlassian Tower in particular, I think, as far as I'm aware, and that's gone through as a state significant development. And then under section, I think it's 4.47 of the EP&A Act, that of course means that the Heritage Act is able to be switched off. So we have a situation where something that is deemed state significant development by its very nature on a state heritage register listed property isn't accorded the benefit of the Heritage Council's proper and independent review of the heritage impact of that development, and that the State Heritage Act that we're talking about here isn't applicable. It's this perverse situation where the bigger the impact, the more state significant it is, the less state protection seems to matter. And the proposals for the Western Gateway at Central Station are particularly disturbing in that they involve destruction of quite a large amount of fabric. They're building within the State Heritage Register curtilage and on top of State Heritage Register listed items. So there is a problem there. And as Mr. Romey has pointed out, once things get so far down the track, it's proving very hard to unwind.
Mr. Romey.
Yes, Peter Romey here. If I can just add to that, the development, we're not talking about the development of Central Railway itself, which is part of the Metro project, which I have to disclose I actually worked on myself. We're talking about the development on 3 sites fronting Railway Square, which I think entirely are public land and involve a number of state heritage listed buildings. Now, Australia Ecomos made a very strong submission about this, and basically the focus of our submission was that the process that led to the approval or it's a stage project of this development was flawed, and it was flawed for a number of reasons, one of which was the Heritage Act was switched off. But as I said before, the other issue is that the process is such that serious heritage considerations into the appropriateness of development are not being brought into the process until very late. So
and by which time, as you point out, Mr. I'm sorry, we just have a very short amount of time. Yeah. You would reiterate your point that once a project has a head of steam up, it can be very hard to stop. Is that right?
Well, if you agree to what's called a planning proposal that allows the existing height controls of around 35 metres, to be varied to 200 metres, and you allow an envelope to overhang a state significant development such as which is the Parcels Post Office, which is a very, very important building.
Mr. Romey, I don't wish to stop you there, but I think I have the thrust of your point, and I think it's for myself, it's well made. I have one final question to both of you, which is, at the moment, the government's the impetus here is to largely do non-Aboriginal heritage, non-First Nations heritage. It seems an odd timing to bring that before statewide Aboriginal heritage reform, given the protections for Aboriginal heritage are found, first of all, in a way that's offensive to First Nations peoples in the National Parks and Wildlife Act. And secondly, Aboriginal heritage is so badly protected in New South Wales. Do you think that the government should reprioritise and work first on protecting First Nations heritage?
Is that directed to me, Mr. Shoebridge? Peter Romey, okay. The short answer to that is yes, and that's a recurring theme in many of the submissions. It's not an area that I have particular expertise in, so if you want a detailed response, I'd have to get back to you on that. But definitely yes. There's a supposition in the discussion paper that Aboriginal heritage be brought into the Heritage Act, but that may or may not be in the long term the right approach, but it's jumping ahead a little bit to say that, I think, at this stage.
David Burton, look, I would just quickly comment there. To be honest, before this review came out, we thought that was the priority. This review that we're in at the moment has come about rather quickly, whereas we know that Aboriginal cultural heritage legislation reform has been something that's been discussed for quite some time. So it would seem logical to progress those discussions before the other ones. That's not to say that the outcomes of this inquiry could and shouldn't be linked together with that, and that the two could work in harmony or whatever's determined by Aboriginal people.
Thank you, Mr. Burden. It's the Chair speaking. I'll invite government members to raise any questions, and if by chance Reverend Niall is able to come off mute, I'll also revert back to him. In the interim, Mr. Martin has a question.
Thank you, Chair. If I could just ask, what does the National Trust use their properties for, and are all properties in use?
Mr. David Burden. Thank you, Mr. Martin. Look, the National Trust has a number of properties. They range from houses for individuals that some of those are actually leased out just as a tenanted basis, but we actually retain the ownership. Of course, we have other properties that are operated as museums. Some of those are run by the National Trust, I'll say, directly, such as Old Government House with paid staff and the like. Others run by our volunteer groups, such as Berrima Harper's Mansion. There are other properties that the National Trust has, such as the Bargo site that we own, which is currently leased to the Australian Wildlife Sanctuary, and so there's a wildlife sanctuary, if you like, and the dingo sanctuary down at that location. So we have a number of them, but our main purpose is to try and open them to the public where that's available, and that's the intention is to increase people's awareness of our heritage in doing so and visiting.
I'll just ask one further follow-up on that, and it's really in relation to the comparison between the condition of properties that are in use compared to the properties that aren't currently in use. What would you say to that?
Sorry, Mr. Martin, can you just clarify, are you talking about properties generally or National Trust property?
National Trust property.
All of our properties basically do have a use, whether that be as a tenanted place or as a house museum. There's only one that I could comes to mind, which is the current site up at the Hunter Valley called Dalwood House, which is currently, if you like, there's a slight ruin up there. But that itself has a group of volunteers that look after the property and maintain it for us.
Okay, good to hear. Thank you. Thanks, Chair.
Any other government members? And I gently
Shane's
remind
trying to come
members,
off mute by the look of it.
I'll gently remind members to take themselves off mute and clearly identify themselves and who the question will be directed to.
I've taken myself off mute. I am Shane Mallard, and my question is to the National Trust, but perhaps both might have an opinion. But I mean, what incentives would the Trust support to encourage and enable better heritage conservation and heritage outcomes? What incentives do you think we should be talking
about? David Burden. Thank you, Mr. Mallard. Look, any incentive is welcome, and they can come in a number of forms, and they don't necessarily need to be financial. I would point that out. My earlier comment about having adequate guidelines and resources are certainly very helpful to owners and managers of properties. There are a number of the financial incentives that have been put forward, and I note those. One that was omitted from the discussion paper, however, was the National Trust's own tax-deductible restoration appeals scheme. That's a very large scheme. We currently have, I think, 68 properties that are involved with that. It's been running for nearly 30 odd years and has allowed nearly $40 million worth of repairs and maintenance works to be undertaken to a number of properties through tax deductibility and donations. So a lot of, we just had one this morning talking about the replacement of a slate roof on a church, and that's going to go through our appeal. So that is quite a big incentive. I wouldn't speak for individual homeowners, but the National Trust that we do apply for and are grateful for a number of grants that we apply for as well to help us manage our properties as well. Not just for their maintenance, but also to run events so that people can come and enjoy them. That's part of that celebrating heritage.
All right. Well, what I mean, I perhaps put a similar question to ICOMOS in regards to what measures would you support that would encourage heritage conservation? What measures do you think are appropriate to support heritage?
Peter Romer here, Mr. Mallard. As I said in my introductory remarks, I think the most effective incentive there is an efficient system that helps people, that is customer focused, so that the owner of a heritage property that wants to make changes to the property is assisted to make good decisions about how to do that, rather than at times to hit what basically it can be a brick wall in terms of just a customer-focused attitude to helping that person. And that comes down to resourcing, not only at the state level, but the local government level as well. And I mean, there are good systems out there. There are private heritage advisors that are partially funded by local government or the state government, but there's not enough resources for them to do their job properly. So having people feel that because heritage is a little bit more challenging than a new build, that there are resources there to help you, not just to hinder you, is a really important incentive. Grants and loan schemes, as David mentioned, a grant or loan to re-roof a house or a property or something like that. There's a number of those. They can be quite effective. And in the past, in my previous experience in different roles, we've learned that there's a significant multiplier effect with those. When an owner is given a grant or a loan, that generates a whole lot more economic activity than just the amount of that grant or loan. I'll just finish off with FSR, with transferable floor space is an incentive that works very well in the CBD situation. It relies on a high degree of development pressure to generate the demand for heritage transferable floor space. It doesn't really work in a suburban or rural situation. You have to look to other means there.
Thank you.
Mr. Chair, if I just might elaborate, just one quick point is just David Burden, sorry, is just on what Mr. Romy stated. Incentives that help with the maintenance of a heritage item can be much smaller, but their longer term effect can be much greater. So rather than wait for the whole roof to disintegrate and the building to become a ruin, a small amount of incentive to repair it initially certainly has a better effect.
Thank you, Mr. Burton. And Mr. Franklin indicated he'd like to raise a question. Thank you.
Thanks, Chair. And thank you both very much for being here. My question is to Mr. Romey. And your submission actually talks about a culture within Heritage New South Wales that doesn't support sympathetic change to heritage properties. I was wondering if you could elaborate on this a little bit and basically talk about your view about what impact this has on the long-term sustainability of these properties.
Yes, Peter Romey, thank you for the question. I just need to be careful with my language, but this is an issue that's arisen in quite a few of the submissions across the board, and it gets back to the point I was making a minute ago, where the owner of a heritage item really feels that should feel that there are people out there willing to help, to assist, and to with advice and if not incentives. That's not always the case, particularly at the state level, and there are some resourcing and expertise issues in Heritage New South Wales that are not what you would call customer focused, and that needs to be addressed. And it's not just Australia Ecomos saying this; there's quite a lot of people who actually work in the area, owners that can give examples of where that there needs to be some adjustment there, as well as better resourcing. And it just comes down to making people feel that there's someone out there to help them rather than hinder them. I can't go into details.
No, that's okay. I guess it's more about the impact that culture has on the long-term sustainability of the properties that we all want to protect. If you had any comments around that.
Oh, well, I think that's right. If owners aren't encouraged to avail themselves of readily available resources and support, they'll go and they'll do nothing, or they'll go and do something else that's not appropriate, and may actually reduce the economic and other viability of the property in the long term.
Thank you very much.
Well, thank you for that. I'll take this opportunity now to thank both the witnesses for attending this hearing. Thank you both to Mr. Romey and Mr. Burden. I think, Mr. Romey, you may have volunteered to take a question on notice, I think, following a question from Mr. Shootridge, is that correct?
Peter Romey here. I'm not sure about that. It was in regard to Aboriginal heritage. I think that I answered it in principle, the question. Okay. But if Mr. Shootridge, I think it was, requires more information, I'd be happy if he could be more specific.
We'll certainly take that offline, and the Secretariat will be in contact in relation to that. As a result of the technical issues that Reverend Noel was subject to, I'll remind him that he can submit a written supplementary question, and also remind members that we will have a lunch break. We will resume at 2 p.m. and keep in mind that to go on mute and also turn off your video during that time. And once again, thank you to the witnesses for their input and participation during this session this morning. Thank you.
And these witnesses are representing agricultural. Were they going to try and Hello, this is Fred Noel here. Can you hear me?
We can hear you, Mr. Reverend Noel.
Okay, thank you. Can you get all the proper pictures on there? Excellent. Can you get it on the screen? Just have a look at it.
Just to the witnesses, it's the chair here, Peter Proust. Mr. Forrest and Mr. Margan, could I just ask you to do we could do a very quick sound check, please, starting off with Mr. Forrest.
Tom Forrest, Open Task Force.
Thank you. And Mr. Margan?
Hi, Andrew Margan from Margan Wines.
Perfect. Thank you. Well, good afternoon and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome our next witnesses, Mr. Tom Forrest and Mr. Andrew Margan. Could each of you please state your name and position title and swear either an oath or affirmation?
Tom Forrest, Chief Executive, Urban Task Force Australia. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Forrest. Mr. Margan?
Andrew Margan, the Hunter Valley Wine and Tourism Association. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Martin. Would either of you like to make a short statement at this stage?
I would, Mr. Chair, if I may.
Thank you, Mr. Forrest.
Notwithstanding the serious concerns that the Urban Task Force has with the Heritage Act and the decision-making framework that has evolved to this point, we very much welcome the opportunity to contribute to this forum and thank the Minister and the Government for bringing on an opportunity to review the Act. We think that's timely and we appreciate the opportunity to participate in that. As we outlined in a fair degree of detail in our submission to the work of the committee, we fear that in some respects heritage has become a weapon in a use against development. That is to say, it's been used by some groups sometimes as if you can't find any other way to stop a development happening, try to find a way to find a heritage item that might stop that development progressing. We don't think that that's helpful. We don't think it's helpful for heritage and the preservation of heritage items to have a conflict between development and the preservation of heritage. I want to make clear we very much support a proper process for the identification of heritage items and for their protection. We welcome the fact that there is now a consideration being given to a tradable heritage bonus scheme, for example, that exists in the City of Sydney at the moment, and that has been applied judiciously and successfully within the City of Sydney. We would very much welcome the expansion of that into other areas, perhaps North Sydney, Parramatta, the Hawkesbury, Penrith, Campbelltown, areas where there are items of heritage that should be preserved. In fact, the more areas you have participating in a tradable bonus credit system or however it might work, the more areas that get involved, the more it's able to effectively work to reward the development community for the protection of genuine heritage items while encouraging the protection of those heritage items while giving them an opportunity to not lose value elsewhere. We are a little concerned about the way interim heritage orders have been applied, that suddenly a person that has bought a piece of real estate in good faith with certain planning development controls all in place can be hit with an interim heritage order which they might not have expected or even anticipated at the last minute. And that has significant impact on the value of their property. In every other area where a government decides to compulsorily acquire or build a motorway next door to your property, there are mechanisms to ensure that the downward impact on the value of that property is compensated. That's not the case in the heritage land, except for some areas of the City of Sydney where that heritage bonus scheme does apply. We think that in a system where there is no financial benefit to the preservation of heritage, where that situation applies, it's in the interest of the development community just to run down the heritage asset. And as happened, for example, in Ryde with the Ryde Civic Centre, the council ran down the heritage asset. The Heritage Council decided it was too expensive to preserve, so they allowed it to be knocked over. Terrible situation, which I don't think should be encouraged. But you can see that if that happens with a council, of course it also happens in the private sector. It's inevitable if the system isn't enabling a reward or an encouragement. Now, ideally, we would like it to be the case that if a heritage order resulted in downward capacity to develop, that you were fully compensated. But I recognise that Don Harwan's unlikely to get a massive cheque from the Treasurer of New South Wales to be able to fully fund that. And I'm practical and sensible about that. That's why things like a tradable bonus system, which is able to reward developers for the active preservation of genuine heritage items that could be used flexibly in different areas where there might be development opportunity to be able to and also there are heritage items worthy of protection, that sounds like a very sensible pathway forward. And thank you to those that wrote the discussion paper for raising that as a possibility. There's a range of other things that we've raised in our submission, but I'll leave that to the members of the committee to peruse and ask questions about as they see fit. Thank you very much, Chair.
Thank you, Mr. Forrest. And similarly, Mr. Margan, would you like to make a short opening statement?
Yes, if I can, thanks. So yeah, I'm working on a project on behalf of the Hunter Valley Wine and Tourism Association, which is a peak industry body here in the Hunter Valley. I have been working on this project for about 5 years, which is trying to get the heritage value of the Hunter Valley vineyards recognised. As the birthplace of the Australian wine industry, we actually have some of the oldest existing vine stocks in the world because, of course, Europe was wiped out with phylloxera, and those original vine cuttings that came out of Europe are still existing here in the Hunter Valley, or direct lineage too. So going through the process, we undertook a study using independent experts. They determined that these vineyards were of enormous, significant heritage value, not just to the state, not just to Australia, but to the world. And within that, we've also recognised that the landscape, the agricultural landscape, the cultural landscape, and the natural landscape that these vineyards all exist in are worthy of protection and have got significant heritage value. They met all 7 criteria in relation to the state nomination list. Where we've hit the brick wall is that under the current rules and regulations, to get to the nomination stage, we need every single landholder to be signing off on it. There's some 600 landholders. Now, around the world, there are some 14 vineyard areas that are listed on UNESCO as heritage sites. There is no agricultural or European agricultural landscape listed as a heritage item in Australia yet. What we're doing in this state, by the look of it, this review, is the potential to be able to have a process that recognises heritage value of agricultural landscapes and the social landscape that goes with them would be significant, I think. Would be a great thing for this state that the Hunter Valley would be recognised for its heritage value through its vineyards.
Well, thank you very much, Mr. Margan. At this stage, I will now invite members of the opposition if they'd like to raise any questions.
Peter?
Yes, well, recognise the Honourable Mark Buttigieg.
Thank you, Chair. Mr. Margan, that brick wall you alluded to, where it requires multiplicity of landowners to sign on, is that a product of the Act not allowing enough flexibility? So imagine if there's 600 landowners, could you not have a situation where if a vast majority were willing to sign on, then that portion would become listed? Or what could you just elaborate on what the issues are there?
Well, you can't what you call Swiss cheese the area. I mean, the area has a boundary. The boundary is recognised under a federal act, which is related to its geographical indication, which is a wine industry concept, but it protects the name of the Hunter Valley. Now, that boundary has then been recognised by the state government through its planning, through its strategic rural land use planning process. But within that boundary is what we call the Hunter Valley vineyards, and the preservation of that whole area is necessary for all the reasons of, apart from preservation of the vine stocks, it also relates to the visual aspect, which is obviously important in terms of regional tourism side of things. And hence, to do it block by block is just not going to be possible. I mean, at the end of the day, what we're looking to preserve is the visual amenity of the area and the actual vineyards themselves. So what we need, there's got to be some rules and regulations in relation to preservation of heritage value of specific vineyards. That's one thing. But then the actual visual amenity of the whole area has to be preserved, otherwise the whole area loses its appeal, if you like.
And just to follow up, so is that just a function of individual property rights? In other words, I might have bought a plot, 20 years ago, and it happens to have those vines on them, but I want to retain my right to develop it down the track, and therefore I'm not signing on. Is it as simple as that?
Well, is it as simple as that? That is a good question. And where we're stuck is trying to do a landscape management plan in relation to it, and that's an expensive exercise. And unfortunately, there's no funding available unless you actually are on the heritage list for that process. So that's where we're stuck there a bit. But reality is, at the moment, there is nothing to protect and preserve these heritage vineyards. And if you were to buy that block of land and pull those vines out, and all of the blocks of land in the Hunter Valley that have these amazing old vineyards on them were bought by people such as yourself, and you just ripped all those vines out, then that resource, which has got significant heritage value, would be lost to the state and the world. And that's what we're wanting to try and stop happening. And at the moment, there is nothing to stop that happening, and heritage Planning Act could possibly help us to stop that.
So just to sort of tie up that line of questioning, so in order to fix that particular issue, which is, I have a lot of sympathy for the arguments you put, it is very significant for the state, that area. You would need to change the Act to cater for the natural environment.
Correct.
But also, presumably, you'd have to put some sort of compensation scheme in place to make it economically viable for those landowners.
Again, I think that would all come out of a landscape management plan, which is where we're up to. I'm not sure. There are some issues around it that have to be resolved. There's no doubt about that. But at the end of the day, we have proven the value of the heritage of these items, and we have to find a way of making sure that they are preserved. And yeah, that's where we're up to.
It's the chair speaking. Mr. Primrose has a question.
Yes, if I can. I actually had prepared my questions for David Borgia from Business Western Sydney, but I'll leave the bulk of those, and just ask the other two witnesses if they could comment on something that was in that particular submission. And I'll just read it out. The David Borgia submission says the interaction between the Heritage Act and the Environmental Planning and Assessment Act needs to be streamlined, and greater clarification of which act should be accorded precedence is needed. And then goes on to say, clarifying the respective roles of each act and articulating who is responsible for what will go a long way to resolving many of the concerns and fears private owners of state heritage items have. I was wondering if either of you would like to comment on that, please.
Mr. Chair.
Yes, thank you, Mr. Frost.
Thank you for the question, Mr. Primrose. That's a very salient point. The matter that I raised and I alluded to in my opening statement in relation to interim heritage orders is germane to the matters that were raised by you just now. It's a situation where you can be compliant with the local environment plan controls. You can buy a piece of property and have an expectation of setbacks, of maximum heights, of maximum floor space ratio, and you can have no hint of a heritage order being applied to a property. And then halfway through a process of the preparation of a development application proposal, sometimes it's the case that a local group might get a hold of this and identify a heritage item out of the blue. Suddenly then an application for an interim heritage order is made, and through the process, the landowner who has bought the land in good faith with no expectation of a heritage curtilage being applied to them suddenly has to deal with a heritage matter. The value of the land that they bought is potentially suddenly stripped significantly, and with no opportunity for any compensation for that stripping. that's where we say we would like to see prospective orders made, where there was an expectation that perhaps every 5 years in conjunction with the preparation of local environment plans or local strategic planning statements, at that time looking forward, councils could clearly identify areas where they think that there might be a heritage curtilage, items that they may want to protect, and where that's the case, there could be a mechanism put in place for some form of compensation for those if that heritage order was to go forward. But at the moment, through this interim heritage order arrangement, there is this conflict inherent between the Planning Act and the controls set up within the planning system that determine the value of the land and the heritage process, which can come in over the top and suddenly strip all of that value away. So you raised a very good point.
Thank you. Can I ask if Mr. Morgan has any comments on that?
Would only suggest that at the moment there is nothing that protects the heritage value of agriculture in this state.
Thank you.
Mr. Buttigieg has a question.
Are we out of time? Because if the opposition's out of time, I'm happy to move on.
No, you're fine. Please proceed.
Yes, just on the Mr. Forrest, on that point where there's no so what is there a process around when that interim heritage order is put on? Is there any mechanism for consulting the landowner on the process and moving forward, and no mechanism for compensation is what you're saying?
What you've said is correct. Once an interim heritage order is applied for by any group, and I know this because I sought it myself for to try and protect the Right Civic Centre. You are consulted and invited to make submissions. The landowner, that is in that case, Right Council was the owner in that particular case. They get an opportunity to say why it is that they believe that order should or shouldn't be complied with, and then the Heritage Council staff make a recommendation to the Minister, and the Minister determines to either place an interim heritage order, which can then be made permanent, or not. There is no mechanism for compensation at all, and the difficulty comes where if you apply for an interim heritage order, if that's done almost as a last minute, sometimes a process has gone through council, the matter's been determined, everything's sorted, you're just about to go and demolish, and I've got my approval, but there's an interim heritage order in place. The minister's stopped me from progressing. That's where it's this sort of gotcha moment, caught by surprise. That's the process which we think undermines the value of property, and it's almost sovereign risk. You think you've got something that's worth a certain thing, and suddenly swoosh, the government takes it away from you. As I said, we don't oppose heritage items being preserved. We don't oppose a sensible process, a logical and clear, understandable process to protect those items. What we are concerned about is that the sort of last minute gotchas that whip value from under you, and then the confusion between the EP&A Act and the Heritage Act as to responsibilities, and indeed all of this without any propensity for compensation at all.
And just to follow up quickly on that, and you're saying that is an exception in terms of the New South Wales jurisdiction. Other jurisdictions all have a compensatory mechanism, or not necessarily? No,
in Australia, it's fair to say that while we're getting to the stage of understanding value for most things, and now even under the Bioconservation Trust, there are mechanisms through which you can put money into the conservation of key environmental assets. That's not the case at this point in most jurisdictions in relation to heritage. There are funds available in Queensland. They're probably the most advanced at having funds available for the compensation of private sector landowners and private sector property holders for the purpose of preservation of heritage. As I've said, we have the capacity here in the City of Sydney to have some bonuses associated with the protection of heritage. So I think Macquarie Street and where the very building that you're sitting in now and its surrounds are covered by a form of heritage curtilage. And by not developing, not so much your building, but adjacent buildings and across the road, the owners of that property were given a bonus to develop elsewhere in the city of Sydney. So they could get an extra floor, they could get an extra floor or an extra piece of height, provided it doesn't cast a shadow over a public park or breach any other condition. Sorry. So that's an example of the sort of thing we're talking about. If it could be expanded beyond just the city of Sydney, because there's not too many areas in the city of Sydney where you can actually put an extra floor on without creating a problem. If it could be expanded to, say, Parramatta, Penrith, Campbelltown or elsewhere, if you had a sort of a tradable system whereby a person got a bonus and then could sell that to somebody who needs a bonus, then that's the way that you could actively have a system to preserve the heritage moving forward.
Thank you.
Thank you, Mr. Forrest. I'll now invite our crossbench members if they have any questions.
Yes, I have one.
Reverend Niall.
Thank you. Just going through some of the submissions that have come into the inquiry, Dr. Peter Watt's submission number 232 says, quote, "I do not support the proposed division of 4 categories as outlined on page 14 of the discussion paper. This adds unnecessary confusion and ranking means that there are places of less significance. A similar system of classification and recording operated by the National Trust was abandoned many years ago for good reasons. So why is it included now as a proposal, I assume from the Minister?"
Could either of the witnesses wish to respond? Mr. Forrest, you were raising your hand.
Well, thank you, Mr. Chair. It is the case that we have a difficult situation here in New South Wales where there's confusion between local heritage items that can range from a fountain or a small asset in a local community park, all the way through to the preservation of the Sydney Harbour Bridge and the Sydney Opera House. It is a little bit confusing where the same rules apply and the same considerations need to be applied by the Heritage Council. For example, sometimes an overshadowing of the proposal to build a building which might be 40 metres away from an electrical power substation, and there's a local heritage order placed on that heritage local heritage listed power substation. You can't then build a building that casts a shadow over that building, over that substation, as if it were the same as if you were building a building that cast a shadow over the middle of Hyde Park, which is obviously an area of public community open space and community interest. In this regard, not having a system which separates the topology or the different categories of heritage asset causes difficulty and confusion. And I think that the proposal, to be honest, that's in the discussion paper is actually a fairly sensible one. But I think it's a very important question worth raising, Mr. Null. Thank you.
Thank you.
Mr. Martin, did you have any questions to share?
No, I have nothing.
Any other questions, Reverend Niall?
Yes, in another submission, Sheridan Burke, submission number 229, says, quote, "Commit to a separate Indigenous Heritage Act, provide appropriate protection, supportive management, requires full consultation, integrated Indigenous values in everything the Heritage Act does. For example, name all sites with their Indigenous countries, etc." Any of the witnesses like to comment on the value of a separate Indigenous Act, Heritage Act?
My understanding, Mr. Chair, is that the matters of Indigenous cultural heritage are being considered separately to this particular inquiry's terms of reference, but of course the Urban Task Force is fully on board, Mr. Nile, with ensuring that Indigenous and cultural heritage is something that we do protect and that we work actively towards. Any system that was put in place to protect physical or environmental assets, if that ends up being the case, should also, of course, be applied to Indigenous heritage. That said, and I'll put the other side of the coin, if that involves the removal of value from those lands, there should be some form of mechanism for compensation so that the private sector, where they are affected, are also encouraged to support the protection of those assets, be they cultural assets, physical assets, or they be environmental assets. All are important, worthy of protection, but they're only as valuable as the state mandates a price to be paid for them.
Thank you. No,
Is that seriously your position, Mr. Forrest, that the cultural heritage of the longest continuous culture on the planet is only valued at the price that the state government puts on it? That's the Urban Task Force position.
No, I apologise if that came, and I would like to rephrase, Mr. And we would say that where there has been value stripped away because of the discovery of an asset, that of course the private sector should be encouraged to preserve that. But I refer back to the Ryde Civic Centre. If there is no compensation at all contemplated, there's not even any encouragement to the preservation, not even a system whereby you could preserve that asset but potentially have a tradable bonus that you might be able to apply elsewhere. In the absence of any form of encouragement, unfortunately, it's the case that inevitably people have an incentive not to preserve, and I don't want that to be the case. I want to see incentives put in place so that we absolutely do preserve those assets.
I fully agree with
Forrest,
that.
you repeatedly referenced the Ryde Civic Centre, and I assume that you recognise that it had substantial heritage value and you thought it should be protected. Is that right?
That is the case.
And to that end, you put in an interim protection order application seeking to protect it as the only way you could do that. Is that right?
It is.
And now you come to this committee and you ask for all the interim heritage protection measures to be statutorily removed and abolished from the Act.
Well,
that seems to me to be, I've read your submission, that seems to me to be a bizarre and damaging proposition.
I understand the point that you make as you've put it. What we've put is two things. That on a constructive basis, we have a prospective mechanism for the listing of heritage items, so that we're not in a situation, and Ryde Council would not be in a situation where suddenly it becomes the case. So if you like, we were using a mechanism, and it was a discovery process for us as well. As we went through the process, frankly, we were surprised at the way that that was the only prospect available to us, because unfortunately, it's the case that because Ryde Council didn't list it as a heritage item, there had been some debate to and fro as to whether or not it should be, but because they chose, the state government had no mechanism to identify this significant cultural heritage asset and had done nothing to ensure prospectively that it might be available. So what we're saying is, through a new mechanism which looks forward in terms of the identification of possible assets, through that mechanism, you remove the need for these interim heritage orders. So if you have a sensible system, I believe you don't need those, because I do believe actually when it comes to private property, they are very dangerous. I'm disappointed in the actions of Ryde Council as a government agency, as having behaved in the way that it did on that occasion. But it is what it is. Democracy does strange things sometimes.
Well, Mr. Forrest, you believe that there should be no capacity to have interim heritage orders issued in relation to heritage or culture that's found on private property, because you prize private property interests over the collective and public interest in protecting the heritage. That's your position, isn't it? And you're pretty bold about it.
It's not that we prize it. We believe that where private property value has been stripped away, there should be some mechanism to preserve that. And at the moment, unfortunately, because there isn't any mechanism in that circumstance, we oppose its being stripped away.
Mr. Martin, I might go to some questions to you, but first of all, I'd just like to note I have a potential conflict of interest. I had a former boss who was much in love with your wines, and I've carried that love on myself. So I come to this with some bias and prejudice in your favour. I'll be clear about it.
Oh, that's fine.
Yeah. When you are talking about a landscape protection, you're talking about a system that's going to, on balance, represent the interests of that community. But inevitably, you're going to have some people who live in that community, landowners in that community, who are against it. But as I understand it, you're talking about the on balance protection for the cultural and historical values in a landscape. Is that right?
That's correct. I mean, there's got to be a level of planning that reflects the heritage value of any specific lot within the area, and there's lots of area that hasn't got heritage value. At the end of the day, as I say, we need to protect the amenity of the area. I mean, I'll give you an example. Coal seam gas. We fought it for 8 years. It was going to be an industrial landscape applied to one of the most beautiful natural landscapes that we have, and we're 200 years old coming up as an industry. So there's a number of layers to this, whether it's the agricultural landscape, the natural landscape. We're talking about Indigenous preservation. I mean, there's nothing more important to the Indigenous than the preservation of natural landscape, and that's part of what we're trying to achieve. The pressures of conflicts of land use are just getting more and more in our area, and we don't have anything that protects the natural landscape or the agricultural landscape.
And indeed, there are maybe one or two listings about cultural landscapes which may reference Indigenous heritage, but I'm not aware of a landscape listing for an area like, say, the Scenic Hills in southwest of Sydney or the Hunter Valley, because there isn't really a mechanism to list and protect a landscape, and that's what you're asking to be included in any reform. Is that right?
That's correct. Yes. Yeah.
And when it comes to the Hunter Valley, the importance for your industry of preserving some of that old rootstock and the old vines, perhaps some of the oldest, as you point out, in the planet, how important is it to the future of the industry that we protect those, particularly the old vines?
Well, as time goes on, more and more important, and the world as it's getting better at plant DNA. Well, I won't bore you with the details around it, but at the end of the day, what they're recognising is, that this is, we have some of the oldest, say, Shiraz vine rootstock in the world, because, as I said, it came from the hill of Hermitage in France, and that was all lost to phylloxera, and we've still got it existing here on its own roots in the Hunter Valley. So that's really important to the world. But I also, think that to the state and to this country, that the preservation of the Hunter Valley as the oldest wine growing area should be important. But it is. I think it is important.
And have you had discussions with, say, the Wanna people and others who I know at the moment have applications to protect their landscape under federal Aboriginal heritage laws?
No, we haven't. We haven't engaged with Indigenous people. At the end of the day, I'm pretty sensitive to the fact that European agriculture came along and didn't necessarily work in conjunction with the Indigenous people when it happened. We are sensitive to that. At the end of the day, European agriculture is what we're trying to have recognised, and I'm not sure how closely that works in with what the Indigenous people think.
It's the chair speaking. Thank you, Mr. Margan. I'll now invite government members to raise a question, and I'll go firstly to Mr. Franklin.
Thank you very much, Chair. Thanks. I might just follow up on that with Mr. Margan, if that's okay, and the line of questioning from Mr. Shoebridge. With Mr. Shoebridge, you identified a couple of particularly pertinent challenges to deal with concerning the listing of landscapes. Are there any others that you'd like to raise in this forum, and particularly any suggestions about how they might be overcome?
It requires the planning department to be involved, for sure. I mean, we as the Hunter Valley are probably the first of maybe a number of agricultural landscapes that may be seeking heritage recognition. And ideally, there would be something in place in terms of planning that anyone wanting to do this could have a look at what it means. As I say, at the moment, we need to hire a consultant to do a landscape management plan to actually tell all the landholders what it means to have this heritage recognition. So ideally, yeah, there would be something in place, put in place by planning. You go, okay, if you as an area want to be listed on the heritage list in this state, this is what it means for all the landholders.
So a codified set of rules and structures that you want, that organisations or communities would go through if they wanted them listed. Yes.
Yes, yeah, exactly. Because it is. I mean, we're concurrently going through the process for national listing, which of course doesn't require any planning instruments attached to it. Whereas obviously the state level, without planning, I mean, and without that landscape management plan to say this is what's happening, we can't go to all the landholders definitively and say this is exactly what will happen if we get this heritage listing.
Thank you. And my second question is to Mr. Forrest, please. Mr. Forrest, in your submission, you talked about, or you raised the issue that some government projects are dealt with expeditiously and positively, like the Sirius building, for example, but sometimes private developments are put through a torturous process that's quite different. I was wondering if you could talk about the difference between those two and what needs to be done to rationalise it so that those two can be streamlined perhaps better.
Well, I guess this goes to the priority that the government has historically and continues to place on heritage assets more generally, that because there are not a comprehensive system support and funding associated with the protection of heritage assets, they focus on what they can focus on. And that means that if the government is priority of the day is the protection or non-protection of the Sirius building, it gets dealt with really quickly and expeditiously, while some private sector developments sit for months and months waiting for whether or not the whole site should be protected, or just potentially the structure and the internal walls, or just potentially certain pieces of flora and fauna on the outside, perhaps the gate and the fence. Relatively simple questions that could be answered, but it's a matter of resources. And if the Heritage Council are not resourced to be able to deal with that, do not have templates and rules to follow, then it becomes difficult, it becomes complicated, it becomes contested, and it takes time. I guess from our perspective, that also equals money. Well, you've got consultants sitting by, they're continuing to draw funds from you. Finances are not so much in interest these days, while interest rates are very, very low. But if you have got borrowings at a higher interest rate, then that needs to be taken into account as well. All of these things suck up money, suck up time. Every time you have to change your architectural plans, that requires a whole series of additional planners, architects, engineering, design. It only takes a small modification to lead to changes in all of those things. All of that takes time and money and can be very frustrating for private sector developers. We'd like to see everything resourced equally and fairly.
Thank you. They're my questions.
Is there another government member with a question? I've just noticed Mr. Mallard raising his hand, and if you could unmute yourself.
Yeah, I'm trying my best.
Your question. Thank
Probably
you.
better if I was muted. Thank you for that. Mr. Forrest, I just want to congratulate you on your campaign to try and save that building at Ryde. I think it's a loss to our heritage international school. I think it's called modern buildings. Everyone seems to think it's all about sandstone. So thank you for the effort you did there. But it does highlight the issue of neglect of heritage properties, and it's shameful that it was a government that actually neglected that one. What incentives would you suggest are needed to encourage the preservation of a property like that? So not demolition by neglect. What suggestions would you have for that?
Look, I suspect I'm realistic enough to realise that the government's unlikely to be in a position financially to be funding the private sector to be actively managing and protecting heritage assets. But there are other ways of doing the same things, and some of those are being canvassed in the discussion paper. And I've already talked about the possibility of heritage bonuses that might be able to be that might be able to be then traded between different council areas, so that you have an active system, which would mean if you don't preserve the asset to a reasonable quality, then you don't get that asset made available to you for the purposes of trading. It creates a value, but it doesn't do it at the cost of the state government purse, which I realise from a treasurer's perspective at least is not going to be a favourable outcome. Nonetheless, it gives an opportunity for the private sector to be effectively encouraged to preserve and protect that asset. Let me give you a practical example just across the road from Parliament House here in New South Wales, 60 Martin Place development. They were able to develop, you may be familiar with the curve that goes out across the next door church. That's taking up, that was effectively recognising that that church couldn't develop upward because it was a heritage asset and they were unable to change it. But they used the floor space ratio that was available to the church, and in return sought to preserve and improve the amenity of that church, as well as provide funding for the lifelong preservation of that heritage asset. So both were a winner. You got a really good building which has wonderful views out to the harbour, will be an iconic asset and way better than the old Westpac one that it replaced. Nonetheless, it speaks to the Reserve Bank building across the road in terms of its architectural design. You've preserved a heritage asset, but also the funding that came out of that arrangement resulted in money going into the church next door to preserve that asset as well. So win-win for all of the communities involved. It's a tremendous example.
Elizabeth Farrelly doesn't agree with you. She thinks it's a thuggish building leaning bullishly over the top of the church. But I agree with you myself. I was a councillor for 12 years in the City of Sydney, and I had a lot of workings with the Heritage Floor Space Scheme. And we'll have to get some evidence about this. But my understanding was, because I wanted to expand it to the whole of the South Sydney area when it was amalgamated into the city, only applies to the core city, the old Frank Sartor core city, is that it's quite a fragile market mechanism. The supply and demand is very carefully managed. That's one. I'd ask you to comment on that. And the second point I want to make is, I think what's really important for the community would be that if floor space ratio was purchased to build it, that the money went back into the local government area. So you talk about Penrith or Campbelltown. There's some towers being proposed for Penrith at the moment, quite big towers. If that involves some floor space bonuses, it goes into preserving some of the heritage villas around Penrith. Would you agree with that?
I do agree with that, but I think that highlights why the system has to be set up by the state government to ensure that a particular area isn't bombarded with a whole stack of additional tall buildings and yet have none of their heritage assets preserved. That would be anathema to the very thing that we're talking about. And for the record, Elizabeth Farrelly and I have an ongoing professional debate, but with respect for each other's views.
He loves to debate. Former councillor as well. Do you know anything in regards to the fragility or the delicacy of the floor space ratio market?
It's a very good point, Mr. Millard. And yes, it is the case that's the problem with the situation at the moment, because it is so fragile. There is such a small amount of developable opportunity within the small confines of the CBD of Sydney. It means that while there is a market in place, it can sometimes take you years to realise that market and to find an opportunity to actually use your bonus heritage opportunity. A lot of work has to be done to identify both the heritage asset and a space in which it might be able to be used. That's why expanding that opportunity more broadly under state government controls would make that market more robust.
So your understanding is that the council, you're entitled to a bonus on your property for a tower. The council has a short list of heritage properties that are on the market for floor space, and then it's the matchmaker. That's how it works, isn't it?
Essentially.
Yeah. Okay. All right, thank you for that. That's all my questions. I might make a question to the gentleman from the Hunter. Sorry, I haven't got your name here.
That'll be a question, Mr. Mallard, to Mr. Margan, and this will be the final question.
Thank you. I'm working on my phone, so it's sorry, Tala, did you want to ask a question? Am I taking your time? No? Okay. No, it was just an observation. So the proposal for categories in this discussion paper would in fact address some of the concerns your landholders have in the region about listing the whole landscape, because I think people, I know from my experience, would be very concerned around different elements of their businesses being heritage listed, like the actual winery bottling sheds or the actual structures. Would you agree with that? That addressing those sort of blanket one size fits all would be a way forward for you?
Well, the thing with structures is that they're generally being captured by the LEPs out of the councils. So any heritage structure has got a recognition. What's not being recognised is the agricultural part of it. But notwithstanding that, I certainly agree with what you're saying. Recognition of whatever it is that's got heritage value and being classified depending on, and we have vineyards that are 150 years old, we've got vineyards that are 100 years old, we've got vineyards that are 50 years old. These are all considered to be of heritage value, but of different heritage value. Of course, a 150-year-old vineyard's got more heritage value than a 50-year-old vineyard. So the opportunity is to have categories to recognise the difference of value. Of course, as time goes on, we're going to have more and more 50-year-old vineyards. We're going to have 200-year-old vineyards, et cetera, et cetera. So there needs to be some ability to have some fluidity in it, if you like.
There needs to be recognition of working vineyards too. I mean, some vineyards take grapes out every 5 or 10 years, don't they? To
yes,
the latest grapes.
Correct. So there's a number of aspects to it. One is a particular site that has been growing grapes for a long time, and whether those, and if I can use, say, Barolo in Italy is UNESCO listed as a vineyard area. They pull their grapes out every 25 years. Having said that, each of those blocks is famous by name. They use the names of their blocks. We're starting to do that here in the Hunter too. The commercial reality of it is that those vineyards should actually be much more valuable. Recognition of heritage in viticultural sense should make their land more valuable, not less valuable, and should make the need to preserve or to have continuity of supply out of those particular vineyards even more important to the people who are growing those grapes who are making that wine. That's what will end up happening. So the ability, what we need to do is, if someone pulls a vineyard out that's of historic value, that we can preserve that stock, number one, so we don't lose the stock. And ideally, if that site has been in continuous production for over 50 years, that it can be kept in production. One of the sustainable aspects of what I'm talking about is the fact is, if a vineyard has lasted 50 years up to this point, it's got to be sustainable anyway. There's no way that anyone would be growing grapes on one site for that long unless it was making very, very good wine.
Okay, thank you.
Mr. Chair, could I just ask if Mr. Margan could take on notice if he had any further developed thoughts about the specific way in which vineyards and vineyard blocks should be listed and protected? Because I know there's the Italian example, but there's also the French example in many of the regions. And if Mr. Margan had any further thoughts to give us that on notice.
Mr. Margan, would you be comfortable with taking that on notice and coming back to us?
Yeah, absolutely.
Well, on that basis, I'd like to take this opportunity to thank both Mr. Forrest and Mr. Margan for attending this hearing and for your participation. On the basis of your response, Mr. Margan, to provide answers to questions taken on notice, you'll have a time frame of 21 days to do so, and the Secretariat will be in contact with you in relation to this and in due course. A reminder to the members of the committee that we'll be taking a short break until 3 p.m. today, and I'll invite you all to go on mute and similarly to switch your respective videos off until that time. We'll resume at 3 p.m. Thank you again.
Thank you, Mr. Chair, and to members of the committee very much indeed.
Thank you.
No, just having a break for about 5 minutes. So my problem is now it's all been turned off. How to get it back on again? So can you stay around here then?
It's the chair speaking, Peter Poulos. Could I just ask Dr. Stewart, followed by Ms. Youssef and Mr. Hogg, if we could have a quick sound check, please.
Okay, my name's Ian Stewart.
And my name is Anita Youssef.
And Neil Hogg is here too.
Perfect. Thank you. Well, good afternoon and welcome to the review of the Heritage Act 1977. The committee is resuming proceedings. I now welcome each of our witnesses, Dr. Ian Stewart, Ms. Anita Youssef, and Mr. Neil Hogg. Welcome. Could each of you please state your name and position title and swear either an oath or affirmation. And we'll commence firstly with Dr. Stewart.
Okay, my name is Dr. Ian Malcolm Stewart. I'm representing the Australian Archaeological Association, and I will take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Ms. Youssef.
My name is Anita Youssef. I'm the president of Australasian Society for Historical Archaeology. I will take the affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Ms. Youssef. And Mr. Hogg.
My name is Neil Hogg, and I'm representing Engineers Australia. I will swear the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Well, thank you very much. Would you now like to take the opportunity to commence by making a short statement? Starting off with Dr. Stewart.
Thank you very much. I have been asked to represent the views of the Australian Archaeological Association, a society of which I have been a member since 1978. I would like to acknowledge the Gadigal of the Eora Nation, the traditional custodians of the land on which we meet, and pay my respects to the elders, both past, present, and emerging. AAA is the largest archaeological association in Australia, representing a diverse membership of professionals, researchers, Aboriginal traditional owners, students, and others with an interest in archaeology. And by archaeology, we take a very broad view of archaeology, including historical, maritime, industrial, Aboriginal, as well as archaeological programs undertaken overseas. The AAA National Executive Committee has worked closely with a range of stakeholders and colleagues, including private consultants, university academics, and strongly endorses the constructive work on the bill by our members. And also we have reviewed quite a lot of the submissions made by affiliate associations, and we support many of the points made in those. A summary of our views follows. The review of the Act's timely given the changing understanding of what is considered to be heritage from when the Act was first passed in the 1970s. The terms of the reference for the review, however, are narrowly focused with particular emphasis on legislation rather than on the totality of the system for heritage conservation and management in New South Wales. We note that Aboriginal heritage legislation reform should have had much higher priority for New South Wales than changes to the Heritage Act. Particularly, we note the long duration of the proposed new Heritage Act to cover Aboriginal heritage, which has been going on for at least 10 years. There are specific concerns related to archaeology, such as the need to clarify aspects of the relics provisions, arrangements for post-excavation conservation and curation of archaeological material. We need to consider how places with both historical and Aboriginal heritage values and Aboriginal heritage values where traditional activity occurred during the period of time after initial contact, and how these would be managed under legislation. It would be helpful also if the review considered benchmarking against best practice in other Australian or international jurisdictions. I now conclude my initial observations, and obviously we'll be able to talk to the points in our submission as we go along. Thank you very much.
Thank you, Dr. Stewart. And Ms. Youssef, would you like to make a short statement to the committee?
Thank you very much. And I also acknowledge the traditional owners of the land that this meeting is held today, the Cadigal people of the Eora Nation, and pay my respect to the elders past, present and emerging. As the president of the Australasian Society for Historical Archaeology, or ASHA in short, I thank for this opportunity to the Standing Committee and Heritage New South Wales to provide my comments and represent my organisation. ASHA is a non-for-profit organisation that was founded in 1970s by the lecturers and professionals of Sydney University. ASHA encourages scientific research and exchange of knowledge on all matters archaeological. We also facilitate publication of the results of these scientific research and studies in our annual journal and various monographs. We organize annual conferences, workshops, and other forums. On average, we have about 300 plus members who include heritage professionals, academics, students, and heritage or archaeology enthusiasts. As part of this review, we have identified several key points as follows. The discussion paper is silent on archaeology, and therefore it is not clear if any amendments would contribute to protection and management of archaeological resources. In its current form, the Act is generally satisfactory. We consider that completing the reform of Aboriginal cultural heritage and legislation has a priority over any amendments to the Heritage Act at this point in time. The issue with the New South Wales heritage management system lies with its interpretation and implementation, which is mainly generated by the lack of adequate resourcing and funding, and also because of various shortcomings. Heritage listing should not be viewed as hindrance. Also, we do not support the proposed listing categories because the current listing system, in our opinion, already allows great flexibility. Thank you.
Thank you very much, Ms. Youssef. And Mr. Hogg, would you like to make a short statement, please?
Yes. Well, Engineers Australia is the professional organisation representing 100,000 engineers throughout Australia and 30,000 in New South Wales. I am the past chair of the Engineers Australia National Heritage Committee, and I live in Sydney. Engineers have a strong interest in conserving Australia's significant cultural heritage, as engineers were very often involved in creating it, operating it, and are still involved in conserving it. you will see from our submission that our general comments and many of our detailed suggestions align very closely with other submissions. For example, we believe that the Act itself is fundamentally sound and that its application and resourcing can be significantly improved. So I would just like to highlight some of the areas of potential improvement which have not been covered in detail by other submissions. So firstly, if we look at the application of the Act and what it has given us over the last 40 years, we can see an extremely unbalanced representation of heritage. People have mentioned Aboriginal heritage, the lack of Aboriginal heritage. Buildings, structures and landscapes have been relatively well served. In fact, over 98% of all items on the State Heritage Register are buildings and structures, mainly pre-1900, mainly current or former government assets, and mainly focused on aesthetic significance. The discussion paper itself is a classic example of this imbalance. It mentions movable heritage twice in the entire document, once in the glossary and once in a quote from the Heritage Act. And intangible heritage is not mentioned at all. And this is a good indication of the attention that they receive in practice. One of the guiding themes that's mentioned is putting heritage to work, which makes me think that I should be doing more to make sure my grandmother earns her keep. We prefer to talk of activating or enlivening heritage. And around New South Wales, there are over 100,000 people who care for items of movable technological heritage in operating condition as individuals or as members of organisations. They spend $700 million each year conserving heritage motor vehicles, trains, boats, trams, planes, and all sorts of other machinery. They raise almost all of that money themselves, but most importantly, they spend it within local communities and as part of their communities. They share their passion and welcome close to 1 million visitors each year. And not only do they preserve the artefacts, they also preserve the knowledge and skills required to restore, operate and maintain the items. By operating them, they allow visitors to learn and create their own experiences. That is intangible heritage. And I'll give an example. The Urana Vintage Machinery Club, a town of 300 people, runs regular rallies with their old tractors, steam engines, cars and whatever. The whole district gets involved and visitors come from all over. They raise enough money to support the local football club, the hospital auxiliary and the local rural fire service. And they do all of this with no official support. At the other extreme, a good example of what can be achieved with professional support is Puffing Billy in Victoria, which attracts over 500,000 visitors a year. Engineers Australia and its members are actively involved in the conservation of all forms of cultural heritage, movable and immovable, tangible and intangible. And we urge the continuation of a strong Heritage Act, a more balanced recognition of Australia's, New South Wales's cultural heritage, and support for heritage at the grassroots level. Thanks.
Thank you very much, Mr. Hogg. And in the context of this virtual hearing, could I just take this opportunity to gently remind members of the committee, as a result of having 3 witnesses this session, if I could ask you to indicate who your question is directed to assist hands up. At this point, I'll invite members of the opposition if they have any questions. The Honourable Mark Butterby.
Thank you, Chair. I just wanted to zero in on a couple of things I picked up there, particularly in respect of the opening statements from Mr. Stewart and Mr. Youssef regarding the silence in the Act on archaeological value. And I'm just sort of reading the sub from the Australian Archaeological Association. I think that's your organisation, isn't it, Mr. Stewart?
Yep.
Well, it says in the that there doesn't need to necessarily need to involve legislative change, but more the emphasis on the application of the Act. That doesn't seem to square with the statements that you both made regarding the silence on archaeological value in the Act. Did you just want to tease that out?
I think we were, if I may go first, we were more talking. Well, there were two elements to this. The first one is that we felt that the issue to do with Aboriginal archaeology was a significant issue that was actually broader than simple archaeology. It was also there's also quite a large number of other issues packed in with that. There has been a long process of attempting to separate out Aboriginal protection of Aboriginal objects and archaeology from the National Parks and Wildlife Act into a separate act, which has not actually come to fruition yet. And our society felt that that was important to have that prioritised firstly. Secondly, I don't think our submission actually said that archaeology was silent in the Act. It was silent in the review. The Act has provisions to do with archaeology, which archaeology comes into two areas. Firstly, a state heritage registered site could contain archaeology of all forms. And secondly, there are provisions in the Act to deal with archaeology, the so-called relics provisions, which are really there as a sort of a way of dealing with the unexpected nature of archaeological finds, largely because we can't see through the ground, so we don't know really what's there until we come across it. So we need to have a slightly different form of protection. But the actual problem is that some of the definitions and some of the issues around the definitions have gone out of whack, and they need to be sort of massaged a little bit to fit in with the broader thrust of heritage. I think that covers the point, and I'll cede the floor to Anita.
Thank you. I also agree with Dr. Stewart, who says that the Heritage Act does cover archaeology, but the discussion paper doesn't. It was silent in the discussion paper. And this is the main issue with archaeology in general, where in the current heritage atmosphere, it's always that buildings are considered and archaeology always secondary or neglected. It is dealt by professionals who are not archaeologists, and many times, or more than regularly almost, we have to deal with statements that are not adequate for archaeology. They don't address archaeology properly, and there is a significant gap because we cannot extract or obtain the scientific information that archaeology may provide as part of the entire site, whether it's landscaping, whether it's building, whether it has historical archaeological evidence or Aboriginal evidence. We want sites or items to be considered as holistically and as one item with multiple facets, inclusive of archaeology.
Okay, thank you for that. Just to follow on from that, so do I interpret from that that the Act as currently configured is probably affords enough scope for protection and conservation of archaeological heritage, but there's a lack of emphasis in terms of expertise to be able to give it the weight and significance that the Act considers?
I think you're right. I think that there are, firstly, some marginal definitional issues that could be altered to make it more effective. And then in the whole overall process, advice to government on archaeological matters is given by a group of, I think, 3 people in the New South Wales Heritage. The Department of Planning, for example, which oversees a vast number of infrastructure projects that are excluded specifically from the Heritage Act has no professional advice on heritage, let alone archaeological heritage. And that causes a lot of problems because they have to deal with complex projects, complex impacts on them, archaeological consultants wandering around doing things that DPI has no idea whether they're doing the right thing or the wrong thing. And that's a sort of limitation, and it can lead to chaos and confusion, and it can also lead to in some cases where public money is spent on things that perhaps didn't need to be spent on. Anita.
It's the same. From my end, we do believe that there is a lack of expertise, or for some reason, archaeologists are considered, or most of the time, overlooked, and archaeology in general is just considered as a great hindrance, or money spent on people playing with it, which is totally wrong. I don't know what perception, how that perception has permeated the understanding of heritage, even amongst our heritage colleagues, but it is the fact. So definitely there is a neglect. Archaeology is not considered as part of heritage in general terms.
Thank you for that. Just one more question, and then I might defer to my colleague, Peter Primrose, if he's got any. But you mentioned in the in your discussion and the submission and the opening statements, the separate act that was being developed to recognise Aboriginal heritage. Did you just want to give your views on the efficacy of that, and whether or not it could be recognised and subsumed into the Heritage Act per se, or do you think it's better off being separate, and why?
Oh, look, I think it's a difficult question. I mean, I think undoubtedly, as a matter of public policy and social justice, it's important to move the protection of Aboriginal heritage out of the National Parks and Wildlife Act, where it is bundled with flora and fauna. I believe the Act is actually very effective in its terms, but it is absolutely terribly bad look to do this, because so often Aboriginal people were treated in textbooks as being part of Australia's flora and fauna, rather than being owners of a country and occupiers of a country for 60,000 years. I believe that it has worked in other jurisdictions well to have Aboriginal archaeology separate out, because there are other issues relating to Aboriginal sites to do with social significance that are perhaps better treated by Aboriginal people. If they're subsumed into the Heritage Act, there is the issue of the potential for non-Aboriginal people making decisions over Aboriginal sites. But on the other hand, if it is separate, that it means that this current situation where you have to get a permit for your historical archaeology and a permit for your Aboriginal archaeology seems to me to be administratively difficult, and you could make it more efficient by, a one-stop shop, obviously. So I haven't got the best answer. I think it's something that it's probably best discussed in a truly with the Aboriginal community as well, and with government, as to how this is best managed. And it may well be that we have to put up with an inefficiency in obtaining permits to obtain a broader social justice for Aboriginal people.
There is a definite division between historical archaeology and Aboriginal archaeology. For some reason, there is a disconnect with these two archaeologies that are characteristic for Australia, and that's not the way how it should be. I personally, from my end, don't agree with the term used, non-Aboriginal archaeology. I mean, the history does not stop in Aboriginal tradition, and history does not stop in 1788. I mean, it continues, but in a different form. So, you know, it's one archaeology with different fields. So there is a lot of overlap potential, primarily when we have sites of so-called contact archaeology, where we have overlap between Aboriginal and historical, where we find evidence of various objects, historical objects being worked and used by Aboriginal peoples. However, in identifying or making a decision how Aboriginal cultural heritage is going to be managed or considered and treated by the Heritage Act, we would really like to see the decision and view of the Aboriginal traditional owners, stakeholders, how they see their legislation, and then after that, we would have to have further discussion as to how to incorporate those values into the Heritage Act and how the two pieces of legislation can work together. At the moment, they're completely separate, which in a way is fine because we are all aware of the legislation, us consultants and professional practitioners. However, there is a huge discrepancy in when you apply for a permit, you know, determination or issue of an Aboriginal permit takes much longer than anything to be issued under the Heritage Act. So that has a great impact on projects financially and time-wise.
It's the chair speaking. I'll now invite members of the crossbench if they have questions.
Yes, thank you.
Thank you, Reverend Noel.
Yeah, Reverend Noel. I noted in the apologies there was one from the Australian Association of Consulting Archaeologists. Did they make a submission finally? Or if not, any of the witnesses endeavouring to bring their concerns before the inquiry of that particular organisation?
I'm not aware of any submission they made, although I believe they may have. They were intending to make a submission. Both myself and Anita Youssef are professional consultant archaeologists, so we have some familiarity with the practice of consulting archaeology, but we probably couldn't speak for, or I certainly can't speak for the Australian Association of Consulting Archaeologists. But if you had any particular questions that you might want to raise about consulting archaeology, I'm sure we would endeavour to answer them as best we can.
Thank you.
If I may say, it is my understanding that the submission has been made, but and the representatives invited, but I don't know why there is no appearance today.
It's the chair speaking. I understand that they were an apology.
Thank you.
That's right, they were an apology. I don't think there was a submission, but there may be one hidden away somewhere. Anyhow, if the government or the people of the hearings could chase them up for a submission, that'd be helpful. The areas that I was concerned about from a historical point of view and so on deals with issues that came out of World War I, World War II, the bombing of Darwin and so on. Is there any provision for archaeological research or material from those events as part of our history?
I'm not, if I may start, I'm not aware of any projects involving that particular site. However, historical archaeology deals with archaeology and heritage of the Second World War. it is a specific branch, so to speak. It is definitely included, but we do not come across these items as frequently in our research and excavations and field investigations as frequently as other types of archaeology. But we do have our colleagues who deal with archaeology of the Second World War.
May I also just add?
I'll just recognise, if the chair's speaking, I'll just recognise Dr. Stewart for the benefit of Hansard.
Yes, speaking on behalf of the association, certainly members of the association have, in the Northern Territory, have obviously been quite active in documenting and researching many of the World War II sites. As well, I would say that I have certainly looked at a number of fortifications around Sydney and Newcastle. Some of this comes into industrial and engineering heritage, which I'm sure Neil Hogg might have some views on. But we've also looked at some of the other sites that are related, such as munitions factories, warehouses, storage areas, airfields, all of which are located in New South Wales. And recently, the Heritage Council of New South Wales has actually listed a particularly unique aircraft hangar at Tokemore. And that's a matter that's before the minister to determine, but the Heritage Council has approved its or put forward its nomination for the Section 60 register. So there is an interest in World War I and World War II heritage. And some of this is archaeology, some of this is engineering heritage, a lot of this is social history, because it's important. People have really important memories of things like the Japanese shelling of Newcastle.
Thank you, Dr. Stewart. Now, I noticed before Mr. Shoebridge raised his hand. You have a question.
Yeah, thank you, Chair. Mr. Stewart, I think you said that the Aboriginal heritage protections under the National Parks and Wildlife Act are working effectively. Do I understand it? You mean that in a very narrow sense, being in the way in which permits can be obtained by archaeologists to study the sites? Or do you mean it in relation to its effectiveness to protect Aboriginal heritage more broadly? How did you mean it was working effectively?
Look, I think that in a narrow sense of sites and physical places, there is a situation where one can apply and obtain permits. There is also a situation where impacts on sites that have not been permitted have been chased up and people have been prosecuted. But generally, it's a fairly old piece of legislation. And I would be, and our association is certainly looking forward to a broader piece of legislation. As you're aware, the legislation was brought in 30 or 40 years ago when there was a different conception of archaeology, particularly at a time when Aboriginal communities were not involved in archaeology. And our society has been active in advocating for a broadening of the understanding of the involvement of Aboriginal people. We think it is absolutely essential that Aboriginal people have control over their own heritage. And also, I referred earlier to a changing understanding of heritage to do with intangible heritage, as Neil talked about, and cultural heritage that's of importance to particular groups such as Aboriginal people. We would be seeking to have a new legislation be broader than just simply dealing with Aboriginal objects.
Mr. Stewart, you would be aware, wouldn't you, that year after year after year of the applications that are made to destroy or harm Aboriginal heritage that go through the National Parks and Wildlife Act, first of all, those applications are not determined by First Nations peoples. And secondly, they have either a 100% approval rate or a 99% approval rate for as far back as I've searched, and that would be at least the last 10 years. You're not suggesting that that's a functioning or functional system for protecting First Nations heritage, are you?
I believe that, well, I don't actually know the figures, but I suspect you're probably 100% on the money. It's an issue that we as a society have been advocating for, which is a change in the way the legislation operates. At the moment, what you're suggesting is a regulatory system so that people can apply for permits and they give them permits. I don't know which ones are refused because I don't necessarily work personally in that area, but I think we do need to change. We do need to have a system that is based on conservation, and that's something I think our society would be supporting.
Yeah, I'm sorry for not. We're very, very short on time. I might just ask Ms. Youssef, do you think the current Aboriginal heritage protection laws in the National Parks and Wildlife Act are at all fit for purpose? And if we were to be urgently reforming one part of the heritage laws, many submissions say that's where we should start, not with European and non-Aboriginal heritage. Do you have views?
Well, look, I agree that, I mean, the current legislation provides some level of protection. What I would like to see, a streamlined approach across various states. I wouldn't make a division between the states because there are various legislative parts that provide different levels of protection. But in terms of the current one, I'm not an expert on Aboriginal heritage. So as I said, to some extent, the current legislation provides some protection, but obviously it's not, I mean, I wouldn't like to comment on that because I believe that it still requires refinement and update to make the process less onerous and more effective.
Could I ask both the archaeologists, if there is to be standalone heritage protections for First Nations heritage, which is primarily determined by First Nations peoples, that to the extent there's any conflict between any reformed Heritage Act and Aboriginal heritage standalone legislation, that when it comes to items of Aboriginal cultural heritage, the standalone Aboriginal heritage legislation should have primacy. Do you agree with that as a basic structure?
Look, I think our society has the view that First Nation people should determine and manage their own heritage. If there shouldn't be a conflict with historic heritage, it shouldn't really be it shouldn't be really up to something like a heritage council that has no Aboriginal people on it to make determinations on Aboriginal heritage. And I think this is a position that the society's held for a long period of time.
I also believe that the legislative protection should be a seamless process. And I'm absolutely sure that whatever the First Nations people decide that definitely can be incorporated into the current legislation. It just would require consultation, more extensive consultation. But when it comes to archaeology, there are no boundaries from our end. We don't separate historical from Aboriginal. We just want to see one seamless, continuous process because that's what, as scientists, that's what we are interested. We are interested in the past. We are not interested in any artificial divisions made. We just want to follow chronological sequencing and to understand, you know, the culture, the changes of the culture, and how it evolves.
But Ms. Youssef, it's not there's quite a distinct difference where the culture, the archaeological sites and the heritage sites are connected to a current continuing culture and history that goes back 40, 50, 60,000 years. It's quite distinct when you're talking about culture and history that attaches to a continuous culture, which is what we have with First Nations peoples. They're not apples and apples, are they?
No, I didn't mean that. There must be some confusion. I'm just saying that we don't want to make a division. we want to have this holistic approach when we go out to the site. I'm speaking from the practical point of view. When we go out to the site, and as a historical archaeologist or a specialist in historical archaeology, I will be considering that site holistically, that in a stratigraphic way, that before that historical period there is another level of occupation. That's what I think. That's what my understanding is about this division. We cannot talk about historical heritage without considering Aboriginal heritage. They can't be divided.
It's the chair speaking. Just double checking, Ms. Youssef, have you concluded your answer?
Yes, I am. And I just want to say that this is my personal opinion as a practicing archaeologist.
Thank you. I'll now invite members of the government if they wish to raise a question. And I noticed Mr. Mallard raised his hand.
Thank you, Mr. Chair. Shane Mallard speaking. Sort of following on that line of discussion around identifying the issues around identifying archaeology. Some of our submissions have said that there are issues and under the current Act about how archaeology is managed and how relics are identified and defined. Do you want to talk about the problems under the current Act and how we should address them in regards to defining relics and managing archaeology?
Look, I think the fundamental underpinning of the problem, I think, lies to the formulation of the Act.
I just say it's Dr. Stewart that's answering the question for hand.
Sorry, I apologise. I should identify myself. But the Act talks about relics, which are artifacts in a sense. They're things that you can pick up. It's not very, but archaeologists manage in terms of sites, places in the landscape, and so the legislation isn't particularly well placed to deal with that. And the definitions in the Act are somewhat vague, particularly a distinction that's been drawn from legal opinion between works and relics. Works being things like a well. Relics might well be an old bottle that's fallen into the well, and some. It's strange that, in fact, you can protect the bottle in the well, but you can't protect the well if it's empty, if that makes any sense. So those definitional things have come along as the Act has been used and as things have occurred. So I think that a lot of the discussion is really about tidying this up. The point about the relics provisions is, in fact, to ensure that unexpected things like the Barangaroo boat, for example, or the historic Aboriginal sites at Randwick can actually have a sort of a mechanism for them to be looked at without having to go through the very lengthy process of assessing whether they're of state or local significance and whether they could be listed or not, because the time frame for that is years rather than weeks, which we need because these things are often found in the context of a development. So I hope that elaborates helps you in understanding those comments.
So the bottom line is we need to have more clarity around the definition of a relic. I
think so.
Which that removes the distinction between works and relics to bring them together. So
yes, look, I think I think fair enough. Sometimes people were saying things were relics when they were really works, and I think the Bull's Head coal loader is a classic case where it was considered to be a relic to try and preserve it, and in fact it turned out to be a work. But but buried bits of infrastructure, I think, are clearly what the framers of the Act back in 1977 were thinking about, rather than this sort of legalistic separation. It would also be helpful if the definition of relics clarified whether human remains were included, because it's not 100% clear that human remains are included, and clearly we would want to have some statutory control on human remains from the historic period, bearing in mind that the coroner's jurisdiction only extends for the last 100 years. And we have recently uncovered human remains from Central Station, as you're probably all aware, that are a little bit older than that.
Yeah, I'm familiar with the ones that were uncovered during the light rail construction over at Central there, in Devonshire Street, and also the Sydney Town Hall when they went down to the level there, about 9 grade.
Absolutely, and those ones from the Sydney Town Hall are outside the coroner's jurisdiction, but we obviously clearly need to have some level of control. It would be helpful to have that clarified, so that it gives greater certainty to the people who are actually administering the Act, and also people who are contemplating doing work in areas where there may be archaeological relics. There's a reasonable chance that they'd be
and that
present.
can cross over and doing Aboriginal heritage too.
Absolutely,
human remains
absolutely.
found at the golf course at Rose Bay, in the sand dunes.
Yeah, I think the classic case is the site at Randwick, where we have now evidence that Aboriginal people took ballast from the ships that were coming into Sydney and took it away and camped there and turned it into Aboriginal stone tools. And there's a lot of other evidence now coming through showing that the Aboriginal people were doing that, which gives us this tremendous insight into how Aboriginal people lived in the immediate post-contact era in a different way from the historical accounts, which were looking at them from the point of view of a First Fleet officer or a government official. So those things are really, really important.
That was an extraordinary find at Randwick to tell us something about the past we didn't know, wasn't it? My next question, thank you for that information. My next question, I think we'll go to Mr. Hogg, and it's the issue which I've always had an interest in, which is mobile or movable heritage, and how that is easily lost. So how would you propose, in the review of the Act, how would we strengthen the protections for mobile or movable heritage to preserve it, to protect it?
I'm not sure. Well, we've made detailed comments throughout our submission, but the Act itself is actually quite good. It uses the term item, for example, which is not used in other states, which specifically makes reference to movable heritage. So it is there. The Act does cover it. Any amendments to the Act have all been about land and buildings and so forth. So all further developments have not taken movable into account. And if you look at the implementation or the application by heritage practitioners and from the Heritage Council down, the results show that it just doesn't get a look in most industrial buildings, for example, when they're preserved on the basis of their aesthetic quaintness. All the machinery that they were built to protect has been scrapped. It's interesting. One of the things that the Act can do, whether it's set out to do it or not, it's interesting to note that at a federal level, there is no protection for movable heritage. The Environmental Protection and Biodiversity Conservation Act specifically excludes movable heritage, and the Protection of Movable Cultural Heritage Act is only concerned about the import and export. So movable heritage at a federal level has no protection. And to stop something being exported from the country by collectors from Germany, US, UK, or whatever, one of the things that the Protection of Movable Cultural Heritage Act looks at is whether it's been recognised, whether the object has been recognised as being of state significance. And as you can see, there are only 27 items in the whole of New South Wales that have that. So recognising something at a state level provides protection at a national level.
I'll defer the question to my colleagues now. Thank you for that.
Thank you, Mr. Maynard. And Mr. Franklin had raised his hand.
Thanks, Chair. Just to pick up on that exact issue, could you just elaborate a little on what incentives might be able to be provided in order to ensure the protection of movable objects? In your view?
Well, a couple of the things that we've mentioned in the submission was that the things that are making it difficult for people are insurance, the preservation of trade skills and knowledge, how to drive a steam engine, how to repair an old car or whatever. This is that intangible heritage we're talking about. That's becoming increasingly hard to get. So that can be helped by like TAFEs and courses and so forth. The other thing is that what the state government has done with the historic motor vehicle scheme is absolutely fantastic. It's quite a small amount of money that's been foregone by the state in reducing the registration costs. But it's activated a huge number of items that have been brought into the public, and one of the expectations is that they must be made publicly available, which is fantastic. We just asked the consideration of a similar system that might be implemented for other types of movable heritage. And in Victoria, the environmental offset biodiversity grants that are made, I think there's a system in New South Wales as well, but where landholders are compensated for protecting significant parcels of land and preserving that land. In Victoria, it's been extremely successful in actually identifying a lot of really important stuff that people didn't know existed, and the landholders are paid to conserve that. It's been really successful, and we're thinking, well, maybe something like that could be applied to movable items. It wouldn't take a lot of money. As I said, these people don't get any support. $1,000 would mean a huge amount to them, and you get a lot of things protected for $1 million. So something like that can incentivize people to do it themselves. It's a very efficient way because they're already passionate. They're already spending a lot of money, and just giving them that little bit of a boost, we believe would make a huge difference.
Thank you. And my final question, if I may, in the previous session, we heard evidence from a very respected winemaker in the Hunter talking about heritage listing of landscapes, particularly obviously of the wine country around the Hunter. I know that obviously in your submission, you had some views about listing of landscapes and so on. And I was wondering if you'd like to elucidate on those perhaps a little.
No, our concern was not about the issue of landscapes. The issue that we had was
the separate categories.
A separate category. I mean, we're quite happy with landscapes, and in fact, one of the concerns that we have is that under the Rehabilitation Acts, it is a requirement to obliterate all record of mining history, for example, because it has to be complete, and we see that as a potential threat to recording our mining history. I mean, in some councils, we know they seem to be ashamed of coal mining, but it's part of our history, and
like that Barangaroo.
And we believe that it should be recognised as a landscape or whatever. That's fine, and all we're saying is that it's just part of the heritage. It shouldn't need to be a separate category.
Understood. Dr. Stewart, I think you might have wanted to contribute to this issue.
Yes, look, I think that working out ways to conserve landscapes is really important because sites don't exist just simply in isolation. It's obviously we need to consider larger areas and how we would manage them. The acts originally were there to create archaeological areas, and I think Plumpton Ridge in Western on the Western Cumberland Plain was one where there was a series of Aboriginal quarrying areas identified, and the protection for that has gradually been eroded away by development, but also further out, and then perhaps turning more to the post-contact, we really don't have very well preserved landscapes relating to the wheat industry, which is a particular hobby horse of mine, and also mining landscapes. And it's a tricky issue. It is really a tricky issue to preserve landscapes, to maintain rights of ownership and things like that. But it doesn't necessarily mean that we don't try it. We just put our minds to it and see how we can get over the obstacles to come to a result. One of the things I've noticed in Germany in terms of preserving their mining landscapes, which are significant, was actually letting natural forces regrow over the area and just allowing what they call industrialized nature to take its course. And so you go to some areas and there are just trees and green everywhere, and yet it's a World Heritage listed coal mine. So there's some scope for looking overseas, which I guess gets back to the point about benchmarking against overseas practice.
Thanks, Dr. Stewart.
And on that note, I'll take this opportunity to thank our witnesses for attending this hearing. Thank you, Dr. Stewart, Ms. Youssef, and Mr. Hogg for your input, patience, and assistance today. Furthermore, I'd like to also thank the committee members for their contribution and the manner in which it was conducted, together with extend my thanks to the Secretariat and IT support for helping to facilitate this virtual hearing. On that basis, I wish everyone a good afternoon, and this concludes today's hearing.
Thank you.
Thanks for the opportunity.
Peter, well chaired.